901.
May it please, Manoj. I had not, when your lordships rose for the day on Thursday, I had finished showing your lordships the 1935 Act. Now, my lord, the statutory landscape. Because my first heading, and I try and race through and finish all the points by tomorrow. First heading, if I may, my lord, encapsulate my point is that the true nature of royalty is to be determined not by semantics, but by the analysis of the, and I deliberately use this, MMRD and MMDR Acts and the rules. The dictionaries don't help one. And that's where in our submission, the case for logic gets flawed.
But by the MMDR Act.
Yes. MMRD and MMDR. The first one was regulation and development, which got flipped to development and regulation. Not that there's any real difference between the two.
Yes.
If I may not show these two, it begins with the 1948 Act. And this, your lordship will find in volume 4, page 891. This was not a rather short statute. Please mind. And this really not focused on conferring rule-making power. Volume 4, sample 4. I should save it on the iPad. Page 891. Your lordship will recall, this is under the 35, so where oil fields were still a part. That adds another nuance to this, which I will deal with separately. It is hereby declared that it is expedient in the public interest that central government should take under its control the regulation of mines and the development of minerals. That's how they understood the two expressions. You don't regulate minerals. That's how the English was. Very carefully worded. Minerals are not defined in the widest possible word. It says minerals include natural gas and petroleum. Mining lease, your lordship may see the definition in D. means a lease granted for the purpose of searching, winning, working, making merchantable, carrying away or disposing of minerals. So if your lordship is not pleased to notice the width of the declaration, it's very wide. And that's why, my lord, the three cases which have not been shown so far, which directly dealt with these. Took the view that there's almost denudation because declaration was very wide. This act, my lord, was thus, it only provided in section 4 that no mining lease shall be granted after the commencement of this act, otherwise than in accordance with the rules made under the act, and anything granted is void. Then 5 was, my lord, the rule-making power of the central government. And your lordship may see. So one is central government may by notification of the official gazette make rules for regulating the grant of mining leases or for prohibiting the grant of leases in respect of any mineral. And then, my lord, in 2, what is important in D, fixing the maximum and minimum rent payable by a lessee, whether the mine is worked or not. That's dead rent. Then, my lord, 6, power to make rules with respects to mineral development. Which again, 1 is the general power. Central government may by notification make rules for the conservation and development of minerals. And then it says in particular, what is important is, my lord, I mean, I'm not troubling your lordship reading the details, my lord. All the dimensions are covered. The technical bits, the working bits. And I says, and I'll read it a little slowly, the levy and collection of royalties, fees, or taxes in respect of minerals mined, quarried, excavated, or collected. Please mark the word, if your lordship don't mind, levying. So your lordship asked a question, my lord, I didn't want to interrupt when your lordship asked that question about if the state can't tax, can the union tax? And the answer given by this court is yes. And that's how all the validation acts were upheld. But that's a separate conundrum. We'll deal with it separately.
But this act is a pre-constitution act,
No. When
1948
after
act.
India Cement struck down, Parliament came with a validating legislation. That was challenged saying, where does Parliament have the power? And your lordship said, well, if the state doesn't have the power, then it goes to Parliament. I call that not the Kannadasan conundrum. Your lordship will have to consider it separately. And it has to be under 97. It doesn't say under what. But well, that's a separate conundrum. Let me not digress.
This particular provision that you have read out just now,
Milo.
subclause I, they have used different expressions. Levy, they don't simply speak of royalty. They talk about levy of royalty, levy of fee, levy of taxes. So these are all used differently.
But
In this,
your lordship will see the rules.
subclause I.
Your lordship may just see the rules. Because what's our case? Let me tell you why I am troubling your lordship showing all this. Once the 48 Act came into place, the exactions were all treated on par. And in fact, in the parliamentary debates relating to the 57 Act, one of the members said, the royalties, which is the tax on minerals, has been now also taken away by Parliament and you're imposing it. Under 9. There was no 9 in the old Act. That's important. Your lordship notices. Now we have 9 under the new Act. There was no 9.
That again speaks of royalty only.
Yes. What is the character of that royalty? We say it's an exaction because when I started, let me not get ahead of myself. I have to show all that. But this is how these were all considered as royalty, fees, taxes in respect of mineral mine. And the word used is levy. Levy is normally a word which one uses for an exaction, not contractual payments. But there was nothing, our submission is going to be, there was nothing contractual left here. It was all statutory. And now we have gone to the extent, well, again, I'm getting ahead of myself, but I want to show all this. We have gone to the extent, if you don't pay royalty, you can be sent to jail. It's a criminal offense not to pay royalty. If a tenant doesn't pay a landlord, you can evict him, you can cancel his lease, you can throw him out, you can't send him to jail. So these are all now statutory exactions.
Does it have anything to do with the word royalty, royal dicta?
Well, today, what has happened
So
is
jail.
totally. It has. I'm so sorry.
It originated in Britain with that.
Okay.
What was given to the crown?
It is what the crown took as its share. And they took everything as their share. That's why originally, I'll show McGarry is a very interesting passage. Except gold and silver. Everything belonged because those are the royal minerals. If you wanted to hunt in the forest, you had to pay royalty. If you took any of the royal animals, to fell a tree, some trees were marked. But it's a very, it started that way. It always started because otherwise, what Malad in English law is called the estate in fee simple, absolute ownership. But everybody was a tenant of the crown. There was no, till now we have freeholds. But so, may I quickly show this act? May I continue? Yes. So, Malad, this is one point which I wanted to make. And yes, I acknowledge the word levy has, it's again not a term of art. Levy can mean charge, levy can mean collection, levy can mean fixing the point of recovery, etc. But what is important is the assessment, everything. But Malad, the important point is the phrase. I'm not putting too much emphasis, but showing how the legislation was drawn. Levy and collection of royalties, fees, and taxes. There's a lot more fleshing out of this in the rules. Then, Malad, section 7, I'll only read the heading. We don't need to get into any details. The power to make rules for modification of existing leases. Malad, if there's anything your lordship want me to show in particular, please. I'm trying to pace so that I finish by tomorrow, Malad. But it's not with the idea to skip anything. And then, Malad, section 10, which was noticed in one of the cases, that all rules had to go before the central legislature. So basically, even if later on the state has made rules, they say you're making it under a union law, you're making it as a delegate. You're not making it in your entry 23 capacity. This is, Malad, the 48 Act. Now it's, Malad, the mineral concession rules.
Mr. Salve, you might read the penalties part, that's section 9, I think.
Yes, Malad. Section 9, Malad. Any rule made under provision of the Act may provide for contravention shall be punishable with imprisonment, which may extend to 6 months or both, which may extend to 1,000 rupees. Now, Malad, this became a lot more sharper in the 57 Act. In fact, I'm going to read the statement of objects only. Your Lordship said a lot of it was, 48 Act was virtually a skeleton law saying everything will be done by the rules. But in 57, the idea was they said, no, we must have a lot more in the Act and lot less in the rules. So it has gone, and one of these cases have now over the decades come to this court. And your Lordships have clarified. If you have a lease and don't pay, you get hit by the Act. If you don't have a lease, like in the sand mining cases, then the IPC will apply. Under this Act, my lord, there was a general delegation of the power to impose penalty under Section 9. And interestingly, my lord, curiously, Section 13, Act is binding on the Crown. Then, my lord, we come to the rules, which are the mineral concession rules. And these are in volume 4I.
Page 28.
Lordships have volume 4I.
Page 28, right?
And my lord, I've got a scanned copy of the book, whatever is convenient to see, my lord. The comparative pages.
Volume
We have ruled,
copy as well, but
Yeah.
we can go to the scanned copy.
whichever is convenient. Scanned copy, page 3 first. Definition of mining lease. Mining lease means a lease to mine, quarry, bore, dig, search for, win, work, and carry away minerals specified. And my lord, minor minerals are defined. Won't trouble your lordship with the detail. And rule 4 is important. The rule shall not apply to minor minerals, the extraction of which shall be regulated by such rules as the state government may prescribe. A lot more flexibility at that time. So the rule making power upon the state came from rule 4 of the central rules. Then, my lord, there used to be a concept of a certificate of approval, which was later dropped, that nobody could get a mine unless he has a certificate of approval. I won't trouble your lordship with that. Come straight to rule 14, which is at page 5. Now, what is important is, my lord, all these apply only to government-owned minerals. That your lordship get from the heading of chapter Roman 3, the heading which your lordship will find at page 5. Yes, it is fine. Why see? It's page 6. It's mine 5. Pagination has gone. Okay. And what is the, I want to show 14 straight away. An application for a prospecting license shall, in the case of land in which the minerals belong to the government, be made to the state government concerned. through such officer, etc., etc. Similar, it is under the union rules that you went to the state. Then 17, and one important feature, I'll just mention it and then I'll show. The whole thing had become statutory, there's nothing contractual. The state used to make orders of grant or refuse orders of grant. And if they did, there was a quote unquote revision before the central government. And then, of course, it used to come in judicial review to the courts under 226. So it became a whole statutory mechanism, right from prospecting license, grant of leases. You passed a statutory order, granted a lease. Somebody who was not happy went to the union government, and the union government decided it in revision. I'll show all those provisions. Rule 17 says, the state government may grant or refuse a license. Subject to the provisions of Rule 13, the state government may grant or refuse a license. In case of refusal, intimation shall be given to the applicant in writing, etc., etc., on the payment of a fees. All this shows the character. There's no contractual this year. You're not discussing anything with the state. Then, Rule 18, I don't propose to read it, just the heading is enough. Priority. So there was a statutory priority on how this would be granted. Then there used to be a register of prospecting licenses under 20. And 23 is relevant. Every prospecting license shall include the following conditions. Please see the first. The licensee shall pay prospecting fee as may be fixed by the state government, not less than 2 annas and not more than 1 rupee per acre of land covered by the license. This is clearly an exaction. And small 2 was in the case of minerals other than gold, silver, precious stones, or mica, the license shall not confer upon the licensee a right to win or carry away the minerals. Then the rest is all matter of detail. So even for prospecting license, you have to pay a fee. And today it may seem very little, but at that time it was not so little. In 48, 1 rupee an acre. If 1,000, 2,000 acres are granted 2,000 rupees, it's a significant amount of money then. Then 24, at page 11, right to mining lease. On or before determination of his license, a licensee shall have a right to a mining lease or leases over the whole or part of the area covered by the license in accordance with the rules. And then the next chapter again is grant of mining lease in respect of land in which the minerals belong to the government. And 26, I'll just read the headings. This was about the certificates of approval, etc., as a condition of eligibility. Rule 27 was the application for a mining lease. The application had again a statutory levy of fees in Rule 28. And then they inserted 28A, which your lordship will find at 13. It said when a mining lease is granted, the formal lease shall be executed within 6 months. So the grant was by an order. So there used to be an order sanctioning the lease, and there used to be, to borrow the words of the rule, a formal lease executed within 6 months. Rule 35 at page 14. With the area of the mining lease, not troubling your lordship with the detail. Rule 40 is relevant, which is at page 15. The period for which a mining lease may be granted shall be 30 years, and for so and so. And for 20 years, other minerals shall ask for a shorter period. Or the lease shall be renewable at the option for 1 or 2 periods not exceeding the duration of the lease in the case of iron ore or bauxite for the manufacture of aluminum, and 1 period not exceeding the duration in the case of other minerals. When the renewal is granted, the surface royalty and surface rent charge shall be at the rates in force at the time of the renewal. Dead rent shall be charged at the rate a state government may fix within the time limit specified in the 3rd schedule in force. Then, my lord, Rule 41, that's important, directly relevant for us. Every mining lease shall include the following conditions. 1, the lessee shall pay royalty on minerals, please mark the words, my lord, dispatched from the leased area in accordance with Schedule 1 to the rules. So this was mandatory. The lease shall have a condition that you will pay royalty on the minerals dispatched. And this has to be in accordance with the schedule. Provided further in the case of lease executed after coming into force, you should not be required to pay during the currency, etc., etc. Then small 2 is if any mineral not specified in the lease is discovered in the leased area, he shall not win or dispose mineral without obtaining a lease. If he fails to apply within 12 months from the discovery, government may give the lease in respect of any mineral to any other person. The lessee shall also pay for every year, except the first year of the lease, yearly dead rent within the limits specified in the 3rd schedule, to the rules as may be fixed by the state government in the lease. And if the lease permits the working of more than 1 mineral, the state government may charge separate rent in respect of each mineral, provided that the lease shall be liable, lessee shall be liable to pay dead rent or royalty in respect of each mineral which is higher. Small 4 is important because when I deal with Murthy's case, this will have some bearing. The lessee shall also pay for the surface area used by him for the purpose of the mine's surface rent at a rate not exceeding the land revenue, and the cess is accessible on the land as may be specified by the state government in the lease. Please mark the words, man. Rate not exceeding the land revenue, and then it is added, and cess is accessible on the land. So that becomes a condition of the lease. The rest are not all technical conditions. I won't trouble your lordship with the details. Rule 42 is the rights of the lessee, the only technical things, working mines, sinking pits, etc., etc. Then, Malad, there was a separate chapter, chapter 5.
Anything with regard to 47, Mr. Sal? Just have a look at it.
Rule 47.
Yes. Says a mining lease granted by a private person.
Yes, I was going to read that whole chapter.
Okay.
It's very important. The provision of the chapter shall apply to mineral concessions granted by private persons. Then, Malad, very interestingly, same conditions are put. You have to have a certificate of approvals. You can't grant it to whomever you like. The conditions of prospecting license are specified. The conditions of mining lease are specified. And 47 is part of that chapter. The mining lease granted by a private person shall be subject to the following conditions. Except leases in respect of coal, iron ore, bauxite from the manufacture of aluminum, for which period the lease shall be of 30 years, all leases shall be for a period not exceeding 20 years. They shall be renewable at the option of the lessee for 1 term, etc. Then 2 is not relevant. That's one interesting and interest. Please turn, my lord, to small 4. The provisions of 1, 2, 3, 4, 5, 7, 8, 9, 10, 11, and 15 of sub-rule I of Rule 41 shall apply to such lease.
Royalties also.
So that takes us back, my lord, to page, I'm so sorry, page 16, sub-rule I, the very first one is shall pay royalty. So statutorily, that's imposed even on when a private person is granting. With such modification that for the state government, the word lesser will be substituted. The lessee may determine. I'm so sorry. And 51 is important. No person in granting or transferring or obtaining a prospecting license or a mining lease or any right, title, or interest in a license or lease shall charge any premium in addition to or in lieu of prospecting fee, surface rent, dead rent, and royalty specified in the license or lease proportionate to such right. I want to state the point so that I want to flag one point here. I don't want to get into it because that's a separate part, but it's very important. Is the state's right to tax the mineral rights granted by a private lease? Question mark. It is possible to argue that exaction, that is not an exaction of the kind which would denude the power of the state. Because the law treats as two separate classes, land vesting in the government and land other than the government. They could have made one common rule saying the royalty shall not execute Schedule 1. It's the same schedule. It's the same rate.
But who grants the mining lease makes a difference. If it is by a private person, then the royalty goes to the
Private person.
private person.
And is that an exaction by the state? The answer is possibly no. Can
Does
that
the
be taxed?
does the nature change merely because the land vests in the state government?
It would. It would. Nature of what? Let me be
The
very
nature
clear.
of the royalty is the same.
No, I'm sorry.
Whether the quantum is obviously the same, but the nature of the royalty, whether the royalty is demanded by the state government or by a private person who owns the land, who owns the mineral rights, is essentially the same.
But the point which That's why the thing is, we didn't open this case. My learned friend, that's why I said 90% of what he argued was non-contentious. The expression royalty is a tax is a very shorthand expression. The real point is something very different. How we developed it to saying royalty is an exaction by the state, which is regulated. And Section 9 displaces any further exactions, which takes to the next step about royalty therefore being akin to a tax, and which then becomes a shorthand expression, royalty is a tax. And that shorthand expression then is treated like a proposition of law, saying royalty is a tax, and then you say, hold on a minute, that's very counterintuitive to say royalty is a tax. What is the real legal principle on which we say that Section 9, and there is a serious change made in the new act, which I will come to. Why do we say Section 9 displaces any possible tax on mineral rights? Is because the limitation contained in entry 50, which says subject to a law on mineral development. The exaction by a state is contained in 9. That it is an exaction is enough for me. I may be right, I may be wrong, but what we are going to show is that if I am right, that this is an exaction by the state, and then your lordship will have to see whether an exaction by the state pegged at a particular figure, whether that can be added to by having a de facto tax on royalty and trying to say, but this is only a measure. That's the real point. Well, this tax, royalty is a tax, this shorthand expression is creating certain conceptual problems. And it's very counterintuitive to say royalty is a tax. I'm only showing it is completely statutory. There's no contractual element left in any of this.
So you are also proceeding on the footing that royalty is not a tax.
Well, not in its classic sense, it's not. It's very counterintuitive to say royalty. The real point which your lordships have to consider is not whether royalty is a tax or not a tax. In fact, your lordships see the questions which have been framed, in the way they have been framed, is what are the real limitations in entry 50? Either we are right or we are wrong. That's the real point. Because this akin to a tax became, oh, therefore a tax, and therefore royalty is a tax. This is one of sometimes shorthand expressions are treated like propositions of law, and then you run into conceptual problems.
Mr. Salve, in the judgments that are under discussion in the present proceeding, did they have an idea to interpret in the constitutional sense what is tax? Because if you go into the definition section of taxation, 366, 28, in those India Cement and Kesuram, they did not have that idea in their mind.
But that's my point. In that sense, nobody said royalty is a tax under 366(28). And that may be taking a point one step too far and one unnecessary step for me. As I started by saying, my case is based on what is the limitation in entry 50. I mean, whether I'm right or whether I'm wrong is another matter. But what is the limitation in entry 50? If there is a complete code of how much a state can receive from land which vests in the state, is that not what occupies the field, and is that not what removes from the state's taxing power the power to tax royalty? Because then you run coach and four through this. The union says, and your lordship will see why. They said states are overcharging royalty at the cost of other states. Show all that in the material. So they said we must fix it. Now you fix the rate of royalty at 50 rupees per ton. And then you say, yes, royalty 50 rupees per ton. And 300% of the royalty is tax on mineral rights. Then what's the use of fixing 50 rupees? And then you pass it off saying, oh, but this is only a measure, this is a tax on land, this is a tax on mineral rights, and so on and so on.
See, there could be various types of exactions on mineral rights.
Yes.
If that is considered to be the imposts or taxes or whatever you may call exactions as a genus, then royalty is only a species.
I'm deeply obliged, and that is why.
Only one aspect.
I'm so sorry.
Sorry.
Your ladyship is absolutely right. In fact, the problem arises when we start generalizing. We have to see each law and see where it sits. this side of the line or that side of the line. It's very difficult in these matters to try and enunciate some sort of a one mantra for all problems. It doesn't fit that. There is a law which my learned friend was defending, which says 1 rupee 50 paisa for any land use for any purpose. Maybe it passes muster. So it may not, this attention to detail, and this is very important because on the one hand, we are balancing national resources, competing equalities. And on the other hand, you're dealing with a very vital power, a power of tax conferred on the state. So we have to be very careful, and the devil lies in the detail in this. You have to look at exactly what is it that we are talking about.
So if one species of exaction is taken away from entry 50, other species of exactions
remain.
are available to the
May
state.
remain.
It will remain, but royalty cannot substitute for all species of exactions.
My respectful submission is that is precisely what this court will have to delineate. What is it that gets taken away, and see the laws which we are concerned. Do they cross the line or do they stay within the line? And I would not submit any generalized statements is where we get into difficulties, because this is a very sensitive area of constitutional law. It's a complex area. And either way, a generalized statement saying, oh, any kind of tax can pass muster, is as flawed as saying no tax can pass muster. But I'm getting ahead of myself. Like if I show all these rules,
Which act has to be a C?
so my lord, the important thing which I wanted to show is that the rules right from 48 had two packages. They did not treat the state as yet another owner of land. And in fact, my lord, Rule 47 mirrored Rule 41. They didn't have one common rule applicable to both. Now, what's the significance of that? I will develop later. Because the state as the owner of minerals, my lord, the genesis of that goes back into our land reform laws. And the later and the currently the national policy 2019 and all, make it more and more clear. We are now talking in terms of intergenerational equity. We are talking of state as owning mineral resources and owning it for public good, etc., etc. No longer, my lord, the concept of the crown. The Raja owned everything. And it's with his permission that you took. You were taking his wealth, so you gave him a part of the produce. That concept has died. What did you give the king? Everything belonged to him. So you take something, you share with him. Land revenue was that, you shared produce. Those colonial concepts will not have perished post our constitution in 50. That's the point which I'm trying to make. So we have to accommodate that. And that is why right from 48, the state as the owner of mineral was treated separately from a private owner. They could just have put everything under 41. One more rule and I'm done with this one. Page 22. There's a complete different track running for state leases. Rule 57. Any person aggrieved by an order of a state government refusing to grant a certificate of approval, prospecting license or mining lease, refusing to renew a certificate of approval, refusing to renew a prospecting license or cancelling prospecting license, refusing to permit transfer, etc., may within 2 months of the order apply to the central government for reviewing the same. This was not called the revision. As young lawyers, we all benefited out of this provision considerably. going to Shastri Bhavan to argue these revisions.
Is it the same as the Mines Tribunal?
Came later, yes. Huh?
Popularly called the Mines Tribunal though.
Yes. Earlier, it used to be a civil servant, a joint secretary or somebody used to sit in here. Even now,
Government, revision to government.
Schedule 1, which imposes, or rather which sets out the rates of royalty, is at page 25. Gold 5%, mica so and so, gold, silver, chromite, oil, shale. Only to show that this was, at that time, it was not ad valorem. It was what, borrowing the excise duty language, except coal was 5% for statutory price. It was what we in excise law we used to call the specific rates, so much per quantity. And the unit used at that time now has gone into disuse, bond. This is the rule of concession rules of 49. I think it may be a better use of time if I show your lordships the 57 Act, the 57 rules, and then go to the judgments.
Right.
Have interpreted.
Fair enough.
Now, my lord, the 57 Act is the original parliament, page 92, volume 4I. My lord, there have been the problem with the textbooks now is there was very serious, very substantial changes made in 2015. So I wanted my lord to see the act as it first came, and that's the this act your lordship will find page 92 at page 92 of volume 4I. My God. For objects and reasons, it's not in this. If your lordships have, it's in the volume 4 statutes, 57 Act. I may have to ask your lordship first to turn to volume 4, page 910. The statement of objects and reasons. That's important.
Same volume? Page 910.
The differentiation made between petroleum and other minerals on item 53 and 54 of the union list has rendered separate enactment necessary. The present bill deals only with minerals other than petroleum at present.
Page 910.
914, I'm so sorry, 914. It begins at 910.
Yes.
The statement of objects and reasons is set out at page 914. The differentiation made between petroleum and other minerals of 53 and 54 of the Union list has rendered separate enactments of the two necessary. The present bill deals only with minerals other than petroleum. At present, both are dealt with under the Mines and Minerals Regulation Development Act. Opportunity has been taken of putting forward this legislation to make some necessary changes in the provision of the existing act dictated by experience. These changes refer to the prescription of maximum 50 square miles, then my lord, second, renewal. Third is authorization of government to undertake prospecting and mining after prior consultation, promulgation of rules. 5 is important one. The recovery of royalty, dead rent, and other sums due to the government in the same manner as arrears of land revenue. And incidentally, my lord, when your lordship had seen the section as to why is this here, my learned friend said, oh no, this is only for some past dues of 48 Act. That's simply not right. It is for dues under this law, because it says under this act. And the old rules continued only to the extent they were compatible with this act. Then, my lord, it goes on further. A number of provisions hitherto dealt with under the rule-making powers of the central government have been transferred to the act in order to restrict the scope of subsidiary legislation. These provisions are, and my lord, we are concerned with small 3. The power to prescribe rates of royalty for various minerals in clause 9 and schedule Roman 2. There was an amendment made in 58, and my lord, some of the concerns flagged need to be seen. If your lordship sees para 2 of the next one, your lordship has statement of objects and reason of the amending act 58. The Mines and Minerals 57, which replaces the act of 48, specifically extends the rate of royalty prescribed in the second schedule to mining leases grantee in respect of coal, and also makes it obligatory for other terms and conditions of the leases to be brought in conformity with the provisions of 13 to 18. It is considered that these changes will have numerous undesirable consequences. The area covered by the mining leases are principally in West Bengal and Bihar, and they account for as much as 80% of the total coal production. The royalties paid on coal vary over a wide range, but are generally much below the rate per ton prescribed in the schedule. A sudden and uniform increase in royalties is likely to have unsettling effect on the industry and may retard the program of coal production under the second 5-year plan. The same adverse effect would be felt by sudden modification. The object is to exempt mining leases granted so and so. I wanted to show this because one of the impact of royalty on development, they are joined at the hip, if one may use that expression. And that's flagged in this statement of objection. That if you suddenly increase royalty, it has a direct impact. And the concern, Malad, because, for example, coal was found mostly in West Bengal and Bihar. And if you increase the rates of royalty, it impacts other states. I will only show, Malad, the 72 Act for the present, and then Malad move to the statute. Statement of objects and reasons for the 72 Act. Over 14 years have elapsed since the Mines and Mineral Regulation and Development Act came into force. In course of these years, large strides have been made in the development of mines and minerals, the production task before the nation. In the fields of steel, non-ferrous metals, fertilizer, chemicals, power generation call for measures of systematic and massive utilization of the natural resources of the country. The Mineral Advisory Board has from time to time reviewed the working of Mines and Mineral Regulation Development Act and made recommendations for amending some of the existing provisions of the introduction of these new provisions. The recommendations cover the following principal points. And small Roman 2 is the imposition of specific obligation of holding of mining leases in respect of payment of royalty for minerals removed by their agent sublessees, provision for statutory basis for calculation of dead rent, etc., etc. And small Roman 10 is important, my lord. The creation of a first charge on the assets of the holder of a mineral concession on account of mining dues. So it is not, my lord, only that the state was treated separately where the lands belong to the state, but that was given a full statutory exaction, or almost it was akin to a tax, because if your assets could be charged, you could be put on penalty, and you could, if you removed it without payment of the royalty to the state, it's a criminal offense. Now, why? The reason is, my lord, and now one realizes why the framers of the Constitution put that limitation in entry 50, while the tax on mineral rights was given to the state. A state richly endowed with minerals, who sees the task before the nation in the field of steel, non-ferrous metals, fertilizers, and chemicals. A state which has a lot of ore of a particular kind. So, my lord, this is very important. I'm sorry.
My lord, I have to speak for myself.
So how this works?
How this works on download and how public text with some facts is a fact.
Union has put a very helpful affidavit, my lord. I'm not going into that because we've divided our work. My learned friend will be showing that. And that is why this limitation was cast. Because, my lord, please consider if this is the perspective, and then you have a free running tax on mineral rights which the state can impose on royalty. It will run courts and forth through all this. It has the potential to run courts and forth.
Then Parliament can certainly legislate by saying
It has.
that these will be the limitations on the taxing power.
It has. Question is, does Parliament have to use that specific word, or is it discernible from the act?
You're saying that the entire taxing power is excluded because this is an occupied field.
It is no. I'm sorry. The necessary implication. My lord, ultimately, it will come down to, if I may say so in all humility, my lord, does Parliament need to say, and the state shall not impose any tax? Or is it clearly discernible from the provisions that this is all that a state was meant to get? It ultimately boils down to that. Because, my lord, if we accept that Parliament can say, and you shall not recover any tax, anything beyond this, is the absence of the words determinative of the matter? Or can one find from the architecture of the law, the purpose of the law, the object of the law, for mineral development, that if you leave this free, then all this mineral development, so much wasted eloquence.
So your contention then is basically that royalty is akin to it's a compulsory exaction.
Yes.
One. Two, being a compulsory exaction, it is akin to a tax or an impost. And therefore, since parliamentary legislation has provided for the quantum of the
How much you can get?
of the levy, which is in the nature of a tax or impost, therefore the state can't.
How much
do that.
Parliament
That's
has
the separation.
said your fiscal exaction from this mineral, which is vested in public trust on you, is section 9 and no more. Now, is that not a limitation which would curtail the taxing power of the state? That's the point. Or does Parliament have to add the words in section 9 saying, and you shall not have any more tax
Because the limitation has to be imposed by Parliament by law.
by law?
But can the law be implied? It has to be
No,
expressed.
the law is there.
It
Question
has to
is,
be expressed.
it is expressed. Section 9 says, and when I develop it, the court will see. When you say you shall recover this and not more than this, I mean, does it really mean, do you really need the words and you shall not impose a tax on this? It can't. Your whole taxing structure, the architecture of the tax on mineral rights becomes incompatible with the law on mineral development.
Shall not recover more than this on account of this particular head, which is royalty.
No, I'm sorry, Manoj. My point is slightly
Once
different.
royalty has been
I
provided
agree.
for,
I agree.
the state cannot say that, well, we are going to demand anything apart from this towards royalty, because then you are governed by section 9.
Manoj, please consider where we are. If you say in mineral development, this is the entire package. And now the law goes this far saying all for the local purposes. Parliament has imposed cesses under the union legislation. And your validation law was upheld on the ground that now this taxing power is only with Parliament. If that's the statute, that's the constitutional landscape, what do we really mean by saying subject to a law in relation to mineral development? It doesn't say taxing power subject to a ceiling laid by Parliament. If it said subject to a ceiling laid by Parliament, one would say, show me the act. Where's the ceiling? Parliament has not imposed a ceiling, you go. I'm getting ahead of myself, but in entry 50, the words are very different. My learned friend's submission has been, show me where is this, where does it say you will not have more than this much tax? That's not what entry 50 says. If taxing mineral rights becomes incompatible with a law of mineral development, your power starts denuded. You don't need a law saying, and you will not recover tax. That is my interpretation of entry 50. Maybe right, maybe wrong.
So you're saying
That's
that
my interpretation.
if taxing mineral rights becomes incompatible
With these architecture of the law of mineral development,
with the architecture stands denuded.
that's right. And my lord, in one sense, while I think when the attorney was making his submissions, my lord, the Chief Justice spoke of the different mantras of list 2.
Yes.
And the real answer lies there. Because, my lord, nothing, no word, no nuance of this should be ignored. Your lordships have always said we look very carefully at the entries. And these are not loosely worded entries. They are not very carefully created entries. Once I've shown this architecture, I have to develop that. But, my lord, there are broadly 3 or 4 kinds of. One is sharing mantra. Parliament will legislate on this, you will legislate on this. Public order other than deployment of centrally armed forces. So you deal with this, Parliament will deal with that. The second is the overlap mantra, subject to law made by Parliament. So there is a shared legislative power with supremacy in list 1. The third is other than those declared by Parliament by law. And some degree of confusion has come, if I may say so, although that they are directly interrelated, of the interplay between 54 and 23, in which your lordship will see those 3 or 4 cases, and the limiting words of 50. They are very different. One is your regulatory power is denuded, but that by itself doesn't denude your taxing power. Or not, if we run a blue pencil through the words, subject to any limitations imposed by Parliament by development. The fact that the state lost the entry 23 power doesn't mean it lost the taxing power. If we are right, and this is a point to be fully developed, I'm just foreshadowing the submission, that 50 is sua generis. And it is not a limitation on your taxing power. That limitation flows from the law of mineral development, not from a legislation per se made by Parliament. And if the architecture of the law of mineral development makes it incompatible to have a tax on mineral rights, then your power stands denuded. That's the real point.
That means the taxing power is not really denuded as such.
It is eclipsed by a law for mineral development.
But the law for mineral development is not exhausted yet. There could be, it is dynamic.
Yes, of course, if tomorrow the 57 Act is repealed, your power springs back in its plenitude.
No, and also there could be various other types of provisions coming up in the interest of mineral development.
That's why again, you have to see what there is.
Yes.
Generalizations create a problem. That's why I start with the acts, the old act, the new act, the rules, the concession, and then say, how do you fit in the power to tax rates? One can't say, look at the entries and therefore your power is gone. Or look at the declaration and your power is gone.
No MMDR Act.
I'm sorry.
If there was no MMDR Act, MMRD Act and MMDR Act, and the state were to enact a legislation on royalty, that legislation on royalty would be referable to what entry?
23.
Right. Therefore,
And
once it is referable to entry 23, a
and-
legislation on royalty is referable to entry 23. Therefore, correspondingly, a central legislation on royalty is referable to entry 54.
There's no problem with this.
Once we accept that a legislation on royalty by the state would be referable to entry 23, the reason why the state cannot impose royalty is because the law is referable to entry 54.
Your Lordship is great respect, absolutely right. The problem is 50 curtails a taxing power with reference to entry 54. And that's the real point of this case. It is not a taxing power versus the taxing power. Well, speaking for myself, quite frankly, the Kannadasan logic is a little hard to understand. Your Lordship will see that. So let's put that to one side, whether if in the absence of state parliament can tax. I start by saying, if state was to fix a rate of royalty, limiting, it would be 23, parliament has done it in 54. The point is just a law of 54 eclipses your taxing rights in 50. My interpretation of 50 is yes, it does. Now, if I'm wrong, I'm wrong. But That's my interpretation of 50, and that's the real point for your lordship to consider. That
Well,
is
we
the
can
structure
do-
of 50.
Right, but to accept that submission, we will have to make one more hypothesis,
Yes.
that any power to tax directly impinges upon mineral development.
Yes, it does. It does. And that, my lord, there can be no doubt. Because if you say royalty impinges on mineral development, if you say a tax of 200% on royalty will clearly impinge on mineral development, because here you will go by the substance. The direct impact and consequence of the law will be on mineral development. And that's the impact of that. I mean, that's the point for your lordship to consider. Because we cannot be, my lord, if one may say so, we protect the state's right to recover. And Parliament has gone to the extent now, post 2015, saying auction, get all the money you can for the mineral. And over and above that, every lessee will pay to a district fund, every lessee will pay to a national fund, a cess imposed by Parliament. And all that money goes to the states. The point is leaving it to each individual state, which really means the richly endowed states, to add yet another layer of economic burden will clearly impinge on mineral development. Either, if my lord, royalty rates don't impinge on mineral development, then of course it is another matter. But if royalty rates impinge on mineral development, then a tax, my lord, this is like an additional tax. I'm not saying it in its legal character. I'm saying in its fiscal effect. 10% ad valorem royalty and then 30% mineral tax on ad valorem means your rate becomes 13%, not 10%. Now, fixing 10% is necessary for mineral development. And then allowing the state to jack it up to 13%, 15%, 17%. It clearly impinge on mineral development. Is it forbidden or not under 50 is another matter. That's, my lord, how it has to work. And that's why, my lord, to see what is on the ground, i.e. the law and how it works, my learned friend will show from the union's affidavit, is very necessary for your lordships to get a real picture of how 50, and then as Melissa said, generalizations don't help in this field. We have to see what there is. Does this obstruct this law or does this not obstruct this law? And quite frankly, my lord, why do I labor the point that it's an exaction? Because the way law has been crafted, it has been taken out of the contractual field. It has been made into a statutory impost. Why all this? To protect the revenues of the state. Because Parliament acknowledges that this is an important mineral resource, it's an important source of revenue for the state. So it must be fully protected. It's statutory. You must enforce it. You can distrain. You can prosecute to make sure you get your exaction. That's not what denuses the power. I'm sorry, madam. It's not that is what empties it up. Our submission is that now let's look at entry 50. If this is what is there, the 57 Act in its original avatar, then modified, now as we find it, is there any space left to have a tax on mineral rights which will not trip mineral development? And that's how it has been seen. And with respect, my lord, your lordship is absolutely right. Regulating rates, Parliament has not, I put Kannadasan to one side. So that puts in one sentence, it is clear if the states cannot tax, Parliament can tax. But that's the logic on which the states manage to save all their collections. But I am not a separate, I deal with it separately. I call it the Kannadasan conundrum. Possibly the understanding was that if by a law on mineral development you constrain entry 23, then the limitation on 97 goes away. So Parliament can tax. It doesn't say so, but that's the only reason which can sustain that.
So, Mr. Savesh, we now go to the 1957 Act.
Yes.
And then the rules and then the judgments.
This was not necessary so that your lordship know in what context I'm showing up. Now, my lord, the 57 Act I'm going to show it in two parts, my lord, how it originally came and now how it stands. Because it's undergone some serious re-engineering, if one may so use the expression, in 2015. What is the old act? If your lordships first pick up volume 4I. इधर ही है. Page 150 onwards. This was before the 2015 amendments. Section 2. It is hereby declared that it is expedient in the public interest that union should take under its control the regulation of mines and the development of minerals to the extent hereinafter provided. Then, my lord, the definitions are pretty much the same. Your lordships have page 150. My lord, this is okay. Page 150. My lord, same definitions. I'll just very quickly show them. Mineral lease is in C, the same thing, my lord, as the previous act. Then, my lord, minor mineral is defined, my lord. Please don't bother with the details. Section 4, my lord, is the prohibition on prospecting or mining operations in any area, except in accordance with the prospecting license or mining lease granted under the Act and the rules. So, my lord, this now cuts through private ownership. Then, my lord, Section 5 is the restriction on prospecting license. I'm not reading all this. Details are not necessary. We can come straight to Section 9, which used to earlier be in the rules, now in the statute. The holder of a mining lease granted before the commencement of the Act shall, notwithstanding anything contained in any instrument of lease or any law for the time being in force, at the commencement, pay a royalty in respect of any mineral removed or consumed by him or by his agent, manager, etc., etc. That is, my lord, pre and post is in 2. The holder of a mining lease granted on or after the commencement of the Act shall pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, or contractor, or sublease from the leased area at the rate for the time being in the second schedule. Please mark one thing, Manan. This will have some relevance when I'm dealing with the entry 50 point. Royalty is specifically, Manan, on any mineral removed or consumed by him. And the state cannot alter this. So it has to be royalty. And it has to be on the royalty removed or consumed, or mineral removed or consumed. And subsection 3, my lord, was that the central government may by notification of the Gazette amend the second schedule so as to enhance or reduce the rate at which royalty shall be payable in respect of any mineral with effect from such date as may be specified in the notifications. Completely, my lord, occupying the field as far as royalty is concerned. What its implications are, we'll deal with separately. And 9A is dead rent to be paid by a lessee. Yes, I'm sorry. Then the proviso says central government shall not enhance the rate of royalty in respect of any mineral more than once during a period of 3 years. Now, my lord, this proviso is very relevant. There is a discussion of this proviso, but it straight away, my lord, provides a response to a question which, my lord, the Chief Justice was pleased to put to me. Does this affect mineral development? Yes, it does. Even the central government's power is reined in. That this will be the rate of royalty, and even you, the central government, will not revise it more than once in 3 years. And this was criticized in the discussions by some people saying, you're reining in, and they said, no, this is necessary to encourage people to develop minerals. You have to rein this in. Then, my lord, 9A deals with dead rent. Holder of a mining lease, whether granted before or after the commencement, shall, notwithstanding anything contained in the instrument of lease, pay to the state government every year dead rent at such rate as may be specified in the third schedule. Again, my lord, shall pay formula. And then, my lord, the rule-making power. So there's quite some discussion of this in the judgments. Section 13, page 154, my lord, your lordship's compilation. The central government may, by notification in the official gazette, make rules for regulating the grant of prospecting license and mining leases in respect of minerals and for the purposes connected therewith. One or two things which are relevant. G. The terms on which and the conditions subject to which any other prospecting license or mining lease may be granted or renewed. So complete displacement. Then, my lord, over the page, I, the fixing and collection of fees for prospecting licenses or mining lease, surface rent, security deposits, fines, other fees or charges, and in the time within which, the manner in which dead rent or royalty shall be payable. I'm only not showing all this to show that royalty now is an exaction. Whether it displaces the power under 23 or under 50 or not is a separate matter. But royalty is an exaction. That's very clear. Then we're at section. May I go ahead? Section 15. 14 and 15. Provisions of 5 to 13 shall not apply to quarry leases, mining leases, or mineral concession in respect of minor minerals. 15. The state government may by notification in the official gazette make rule for regulating the grant of quarry licenses, mining leases, or the mineral concession in respect of minor minerals and for purposes connected therewith. And this, my lord, is virtually, this echoes 13, except that it's the state government which makes the rules. And your lordship will find here in G, 15G, the fixing and collection of rent, royalty, fees, and other charges at the time and within which the manner these shall be payable. Now, this fixing of royalty by the state is also under central legislation. And that has some bearing, as your lordship, one of your lordship's constitutional bench judgment notices, on the denudation point. And just to complete, my lord, section 20 and 21. The provision of this act and rules made thereunder shall apply in relation to the renewal after the commencement of this act of any prospecting license or mining lease granted before such commencement, as they apply in relation to the renewal of a prospecting license or mining lease granted after such commencement. And then, my lord, 21. Whoever contravenes the provisions of subsection 1 of 4 shall be punishable with imprisonment which may extend to 2 years or 10,000. And that, my lord, 4, now of course it is far more clearer after a lot of amendments have been made. This is where you operate other than in accordance with the terms and conditions of a mining lease. And one of the terms and conditions is payment of royalty. Some more sections have been inserted which make it even more direct. But even initially, now obviously, it loses its contractual character. That, my lord, is as far as the act is concerned. 29, 25. Yes, I'm sorry. Yes, I should have shown that one. Section 25, page number says. Page 160. Any rent, royalty, tax, fee, or other sum due to the government under this act, or the rules made thereunder. But I do not argue, let me make it clear, that merely because of this royalty becomes a tax. That's not a wrong way of reading this section. Suffice it to say, royalty is now a statutory exaction. Does it displace a tax is another matter. So you have to take it step by step. But penal provisions and provisions such as 25 make it a statutory impost, if one may use a neutral word. And this impost is for mineral rights. The state, the mineral rights are granted under a central legislation. by the state, not by the state under its own legislation. The state is creating these mineral rights now under a central legislation and is allowed to charge a sum of money, which is a statutory impost. I get that far. And on a first schedule, just for the record, is,
Mr. Salve, before you go to the schedule,
yes, mine.
this delegation power under 26. Central
Yes.
government gives power to the state to do everything that is there under the act.
As a delegate of the union.
That's right. So what is this thing? Are you trying to?
No, no, this is a power under entry 54, not under entry 23. It doesn't restore entry 23. There's a world of a difference between the state. Not the Air and Water Act. Say the state will, the state will. You are acting under union legislation. Your legislative power is not being restored. The union says, I will, because all these rules, the union can tomorrow correct you, withdraw you, take it away. When the state acts, it's sovereign to its limited extent. The union can't tell the state, make a rule like this, don't make a rule like that. But here, it's under the delegation of the union.
54.
So it's virtually the union granting the lease.
That's right. It is, my lord, the union saying, this is how you will create these mineral rights. And this is what you will charge for it. Does that amount to the kind of limitation 50 contemplated? Question mark. I will deal with that.
Yes.
Let's not mix up all the points. But at least let me be clear as to how far I have got. And this is not all, fortunately for me, I don't need to reinvent the wheel on this. There are 3 judgments which have said this. But reading Kesaram doesn't help. That's why, in fact, I thought I should be opening a case by saying why Kesaram is wrong. Saying Kesaram is right, and of course it says what it does. These are the real points of this case. And these are the questions referred to your lordship for resolution by the referring order.
Then how to interpret entry 50 remains.
Now, my lord, I'm sorry. But there's a lot of what your lordships are hearing is nothing new. The late Mr. Nariman had said all this when we argued India Cement, the privilege of being with him. But it didn't get captured in the judgment, that's all. And my lord, finally, there was one point made just to deal with it. Section 29. So then my learned friend said section 25 was only if there's something which continued. Even the old rules don't continue in full. All rules made or purporting to have been made under the Mine and Minerals Regulation and Development Act 1948, 53 or 48 shall, so far as they relate to matters for which provision is made in this act, are not inconsistent, be deemed to have been made under this act as if this act had been in force on that date on which such rules were made, and shall continue in force until they were superseded by any rules under the act. So, my lord, this is the usual adapting provision, saying rules will continue to the extent consistent with the act. And then, my lord, 30 is the power of revision. And that's important. Because the union, my lord, so pleased to ask me, is the state acting on its own? No, because the union, see the power of revision, my lord, to which the central government may of its own motion or an application made within a prescribed time by any party, revise any order made by the state government or authority. For major minerals, it's complete blanket power of the union.
The second schedule gives us the royalties now.
Yes, and that's only one address to show that. Schedule gives the royalties. Some are allowed, for example, for precious, semi-precious stone, it was ad valorem. Sale price at the pit's mouth, some was per ton. Sometimes a lot of these simple expressions become so complicated with technology. Pit's mouth is easy to understand. But when you produce gas, what's the pit's? What is the price? Wellhead price. That which is 2 kilometers under a kilometer of water, or that which is at the flange point after the gas is clean. Now, my lord, this is, as far as this is concerned, the act as it was. Please see the, Mineral Concession Rules 1960, and then I'll show some of the amended provisions of the act. Regulation India. Left the name. Session goes from your book. I don't know. Where you are. Same volume 4I. Volume 4I, madam. And my lord, very quickly, if I may, show material parts. My lord. The certificate of approval got jettisoned. Then, my lord, chapter 3 again divided between land in which minerals vest in the government and even whether minerals vest in the state government. All the grants are under the union legislation. All the steps are under union legislation and union rules, because the MC rules were made by the central government. Well, I'll just give the numbers, go it quickly. Rule 9, 10, 11, 12. Say how it is to be granted. Again, a statutory mechanism, but the details are not very important. 14 is the conditions of a prospecting license. And your lordship will just see that again. Page 237. Every prospecting license granted shall, in addition to any other condition that may be specified, subject to the following conditions, namely: 1, the licensee shall pay such prospecting fee as may be fixed by the state government, being not less than 50 paisa and not more than 5 rupees per hectare of land covered. Then, my lord, we have under chapter 4, unless there's anything specific your lordship want me to read, I'm just skipping through. Chapter 4 begins page 239. Application for grant of mining lease, which vest in the government, shall be made to the state government in Form 1 through such officer or authority as the state government may specify. So that action of the state government is of specifying an authority also is under the union rules. Then sub-rule 4 says once the government receives an application and has decided to grant an area to an applicant, it must communicate the precise area to the applicant. Then what the mining plan must have. And if we move on, Madam, Rule 24 is disposal of application for mining lease. This is Madam where the orders were passed. Now, it's interesting to see Rule 26. page 242. The state government, after giving an opportunity of being heard, and may, for reasons to be recorded in writing, communicated to the applicant, refuse to grant or renew a mining lease for a whole or part of the area. The whole understanding, these are minerals vested in the state, they have to be developed, we need private capital to come in. It's all becoming extremely tightly controlled by union law and union rules. Then, my lord, conditions under Rule 27. Similarly, my lord, 27(1)(c) is dead rent, 27(1)(d) is surface area, surface rent, and please mark, my lord, it says water rate in D. So the water rate is imposed here. Now, what is interesting is, my lord, 27(5). Which page is it? 242. If the lessee makes any default in the payment of royalty as required under section 9 or the payment of dead rent as required under 9A, or commits a breach of any of the conditions in 1, 2, and 3, except the condition referred to in F of 1, the state government shall give notice to the lessee requiring him to pay the royalty or dead rent and remedy the breach within 60 days. And if the royalty dead rent is not paid in the breach, not remedied, the state government may, without prejudice to other proceedings that may be taken, determine the lease, forfeit the amount of security deposit. So even this is not under central rules. So the entire operation of mineral rights, the creation, the administration, the terms and conditions, and its determination. The minerals vest in the state, the mineral development is entirely under the union. And again, my lord, Rule 31, because this, my lord, puts us onto the form.
Yes.
Then, my lord, Rule 31, where on an application for the grant of a mineral lease, an order has been made for the grant of such a lease, a lease deed in Form K or in a form as near thereto in circumstances may require, be executed within 6 months. So this is now, my lord, a statutory form which sets out how the lease is to be granted. Here again, my lord, there is a separate chapter 5. Which page is that? Page 247, which deals with minerals which vest in a person other than the government. I won't trouble the lordship with the details. It has the same thing, including no premium, conditions of mining lease, etc. But for the state, the mining lease has to be in Form K. And finally, my lord, in chapter 7 is revision. Any person aggrieved by any order made Any person aggrieved by any order made by the state government or the authority in exercise of the powers conferred on it by the act or rule may within 3 months from the date of the communication apply to the central government in triplicate for revision, etc. It's a complete control by the union. On Rule 72. Now, my lord, there's an important point to note, page 251, because this will have some bearing, my lord, when I deal with the entry 49, entry 50 point. The holder of a prospecting license,
Which provision?
I'm so sorry, my lord, Rule 72.
72.
The holder of a prospecting license or mining lease shall be liable to pay to the occupier of the surface of the land over which he holds the prospecting license, or as the case may be the mining lease, such annual compensation as may be determined by an officer appointed by the state government by notification on this behalf, in the manner provided in Rules 2 to 4. So, my lord, the distinction is made between the mineral rights and the surface of the land. This will have some bearing on, my lord, whether you can say I'm taxing the surface rights, and the measure of that is the value of the mineral rights. Which is the Murthy logic.
Entry 49.
Entry 49, it's a tax on surface rights, but the measure is the royalty. So this is one, the form K begins at page 264. One or two important things, one or two in this. I want to show this because it's important. It speaks of royalties to be paid, no question about it. And that's at in part 5, page 267. And surface rent and water rate. Not the details are not relevant. I'm very quickly just showing the provisions. And part 7, covenants of the lessee, is interesting. The lessee shall pay rents, water rate, and royalties reserved at such times as may be provided, and also pay and discharge all taxes, rates, assessments, impositions, whatsoever being in the nature of public demands, which from time to time shall be charged, assessed, or imposed by the authority of the central government upon or in respect of the premises and works except demands for land revenues. So, my lord, this is important. This contemplates public demands which shall from time to time be assessed or imposed by the authority of the central government, not by the central government. That means the power flows from the central government. Whoever may be whether it's done by state, an officer of the state, or done by an officer of the center. That's it. That's not, unless there's anything else I can show a lot of. That's as far as is relevant for the present. Yes. Oh, well, not like the previous renewal. Similar, I didn't not read it because it's pretty much the same as the 48. Now we may not come to the new act as it now stands. My lord, this should again be in volume 4. Begins at page 910. Go back.
The water rate. What is that water rate?
My lord, I
I'm
have tried
thinking
to
about
check.
something. I do not know
I will
whether
try and answer the question tomorrow, my lord, because these are
No,
such
no.
old,
No, correct. Because
it could be under local laws.
it may have nothing to do with the law, but when Jamshedji, the original Jamshedji, he wanted to set up steel plant. So for steel, you need iron ore.
Yes.
I am remembering what is written by R.M. Lala in Beyond the Last Blue Mountain
Yes.
book.
Yes. Yes.
So there, he brought, I think, the expert from Paris, perhaps, one who was identified as a world expert. He brought him, and they were traveling on elephant back to find out where the rich iron ore could be available. And eventually, they found a mountain of iron ore
Yes.
where I think the percentage is about 60%, which is very high. But then they realized that there's no water, because water is essential in order to extract the ore.
Yes.
And then they said that it's not going to work out. But suddenly, just after some steps on bullock uh, uh, carts and elephants, they suddenly found a vision of two rivers or three rivers converging and a huge water body. And that is where I think the Jamshedpur, the current Jamshedpur is located.
Yes.
I think that's this water thing is a very relevant
It's
thing
very,
for mind.
in fact, if one goes, I didn't want to enter that, my learned friend is going to be
So
showing.
we are trying to distract you a little.
No, my learned friend is going to show that part. Mineral development today is a very highly complex. In fact, one of the problems today which people criticize is because of all this which we have created. India has 17% or 18% of the world's mineral resources, and we import iron ore. We import coal. And that is why, Manoj, we are now taking a very firm position, even with the COP, that why should we give up our coal resources? The Western world has finished off all their coal resources and now lecturing us, saying don't use fossil fuel after they've exhausted their fossil fuel. We still have our fossil fuel lying very much in the bowels of the earth.
The Chief Justice was mentioning generational equity,
That's right.
intergenerational.
And that has now come in, Malad. In fact, so many of these concepts, that's the act which I'm going to show now, have come in. And how tight the scheme has become. And now we have acknowledged, Malad, we flirted with the idea of saying this must all be reserved. There was a time, Malad, we used to all challenge reservation by states. For public sector, reservation by this, reservation by that. All that led to is a decline in the production. Even coal mines, Malad, now gradually we are seeing the production of coal going back into private hands because the technology, the capital investment, and the efficiency is far greater. In a resource where you allow the private to come in and control them rather than do it yourself. So these are all changing ideas. And the idea now of the act, which somewhere along the way, I mean, as they say, what's in a name, but somewhere along the way, the Regulation and Development Act became the Development and Regulation. It only shows the increasing concern over development. Earlier concerns were about reining in private exploitation. Now it is more about developing our resources which are held for the benefit of the people. So there's a shift in ideology. And I'll show Malad the National Mineral Policy of 2019 when I close this part of the session. The new act, Malad, if your lordship sees, and the act is now stands. Declaration is the same, Malad. So I won't read it. Please notice some definitions added. AA, 3AA.
Is the act here in
Yes,
the
yes,
short form?
it's there. I'm saying, page 921 onwards, volume 4. I'm using the book because I'll be able to give you lordship pages, but I found it very difficult because somebody has copied from SCC online. And that in between has commentaries, judgments, and then the next section, you don't know where the commentary ends and where the section begins.
Yes.
3AA. Dispatch means removal of minerals or mineral products from the leased area and includes the consumption of minerals and mineral products within the leased area. The other definitions are not pretty much the same, so I won't trouble your lordship reading them. 4 is the same. And what is interesting, my lord, to note, apropos the question which your lordship was, the comment which my lord made, 4B, notwithstanding anything contained in 4A, the central government may, in the interest of maintaining sustained production of minerals for the country, prescribe such conditions as may be necessary for the commencement, continuation of production by the holders of mining leases who have acquired rights, approvals, clearances, and the like under 8B. Page 936, Malad. I'm sorry, I should have done the data. Malad, today, the old notion of sovereign, etc., is all, today it's all seen as a partnership. So if you're given the mineral, it's not for your private humor. You have to sustain production, and if you don't, the government can make rules. If you're not keeping up the pace of production, get out. Somebody else will come in and do a better job. In fact, my lord, yes, I'm grateful to my friend. One of the conditions added in the old termination provisions, in fact, please see 4A, my lord, it's very important. Where the central government, after consultation of the state, is of the opinion it is expedient in the interest of regulation of mines and mineral development, preservation of natural environment, control of floods, prevention of pollution, or to avert danger to public health or communications, or to ensure safety of buildings, monument, or other structures, etc., etc. Request the state government to make a premature termination of a prospecting license. Just one. So, Bharat, this is the first, and a lot of changes have been made, Bharat. I remember one of the things we struggled here in the forest matter was to get the Karnataka mines closed, state mines, which were creating pollution. Now it's become statutory. And subsection 4 of this is the mirror image of, is the other side of the picture, where the holder of a mining lease fails to undertake production and dispatch for a period of 2 years after the execution of the lease, or having commenced production and dispatch, has discontinued the same for a period of 2 years, the lease shall lapse on the expiry from the date of execution, and maybe the discontinuance of production and dispatch. And then we have 4B, which is efficiency. So today, Malad, it's more, you are really working a concession, not just for your private gains, but as a part of the overall mechanics of mineral development. Then, Malad, the periods for which such leases may be granted is statutorily controlled under sections 7 and 8. I won't trouble your lordship with the details. And then we have section 9. This is at page 942. The holder of a mining lease, 9(1) is the past, not commencement of the act, notwithstanding anything contained in the instrument of lease or in the law in force, etc. Pay royalty at the rate for the time being specified in the second schedule. And subsection 2 is at current times. Holder of a mining lease granted after the commencement shall pay royalty in respect of any mineral removed or consumed by him, by his agent, etc., etc., in the leased area. If your lordship see this now and go back to section 4(1)(a).
What page should that
Yes,
be? The
I'll
PDF page?
you get that. 4(1)(a). 924. No person shall transport or store or cause to be transported or store any mineral otherwise than in accordance with the provision. So 4.1 is not the same. No person will undertake reconnaissance, prospect or mining operations in accordance with the terms and reconnaissance, etc. And now transportation expressly is brought in. And if your lordship sees section 9.2, it says royalty on mineral removed or consumed. So if you are transporting it without paying the royalty on mineral, you're violating 4. And if you're violating 4, it's a criminal offense. That is one important dimension of the matter. Then, my lord, two other new provisions which your lordship must see are 9B and 9C. How, my lord, these operate are there in the affidavit of the union, but my lord, then its solicitor will be showing those. We don't want to duplicate work, so I'll just show the provision and the legal implications. So this is what the states used to always say, that you take the people take the mineral away and we are left with the baby. We are the ones who have to deal with the areas. So 9B is very important. In any district affected by mining related operations, the state government shall by notification establish a trust as a non-profit body to be called the District Mineral Federation, a foundation. This came in 2015. I may just anecdotally take 5 minutes, 2 minutes distraction here. This was first done by your lordships in the Vedanta case when granting environmental claims. Your lordship said for that area you will set up a trust headed by the chief secretary, the people from the company will be there. Of the top line, you will contribute a percentage and that will be used for development of that area, the Lanjavar mining. The government, despite which, didn't grant the lease, but that was another story. But that was first brought here. Two important things have been brought by lordships, and it might, I don't know whether your lordships have ever seen the details. The NPV judgment, the net present value judgment, on how and it started with mining, because when you start diverting forest land for non-forest purposes, it's not enough that you pay for the tree or you pay for the land. You have to pay the net present value of the loss to ecology. And there are now complex mathematical models on how that is to be calculated. Your lordship's judgment on that one. That's the intergenerational equity, how your lordship started, and now, of course, the statute has picked up. And now 9B is a rule. Here again, it's under union legislation. Yes. This is under union legislation, so the state does it under union law. And then, my lord, the rate is at subsection 5 of 9B. The holder of a mining lease or a composite license granted on or after the date of the commencement of the Act 2015, as covered by subsection 2 of 10A, shall, I'm so sorry, in addition to the royalty, pay to the district mineral foundation of the district in which the mining operations are carried out, an amount equal to such percentage of the royalty as is paid in terms of the second schedule, not exceeding 1/3 of the royalty as may be prescribed by the central government. Well, this is exactly what the taxes are doing. So this is not an imposed by the state. It's an imposed by the union. I'm deliberately using a colorless word, but not imposed. You call it a tax, a fee, or something in between. And this is exactly what number of the laws under challenge purport to do. The holder of mining lease granted before or after the commencement of the act shall, in addition to the royalty, pay to the district mineral foundation in which the mining operations are carried on, an amount not exceeding the royalty paid in terms of the second schedule, in the manner and subject to categorization. So, it's royalty and an amount not equal. So the same thing all over again. You have to pay. Why not this? There's a small thing which your lordship directed by way of NPV. I don't know what the figure stands now, but last when I was assisting your lordships 10 years, 8 years ago, 9 years ago, I think it had hit about 40,000 crores, 50,000 crores. The interest on which was enough to do so much for the states. And I do remember, we got a request from the people in Assam, the forest rangers saying, can we have some money from this? So an application was brought by the CEC, that Centrally Empowered Committee. The Micas, I used to move those applications. And what did they want? They wanted 8 lakhs or 10 lakhs. They said, we want to buy 2 gypsies. So, and 2 or 3 guns so that we can chase the poachers. And that little amount made so much difference in containing poaching. So, these funds are properly utilized. There's so much which can be done. And these are large amounts of money. Livingston will give the exact figures. These are large amounts of money. Then there is another under 9C. The central government shall, by notification, establish a trust as a non-profit autonomous body to be called the National Mineral Exploration Trust. This is not for doing exploration work, and in subsection 4 of 9C, the holder of a mining lease or a composite license shall pay to the trust 2% of the royalty in terms of the second schedule. Please mark how it is done, 2% of the royalty.
But these have all come in 2015.
Yes.
But we are considering the acts prior to this.
No, of course. My submission is going to be even before these sections were put in, what was the connotation of mineral development? These sections are these are all mineral development sections. So if that power was taken away, it was for the union to do it. The union waited till 2015 to do it, but they've done it. But if the power was not available, the limitation came in. It came in by the overall act. And realizing that limitation is taking away the power of the state to raise resources, the union is now filled in the gap. I'll not deal with this more fully, but just to show, this is now the new structure. This is one. The second very important change which has come is section 10B. Page 948. Because now the state cannot grant mining lease by an order, etc. It has now all to go by auction. But I'm deliberately not reading 10A. There are a lot of cases pending on 10A. There are some construction issues. Anything said by 9 judges, my lord, will, even by, in passing, will affect those. 10B is what we are concerned. The provisions of this section shall not apply to cases falling under 17A. Then minerals specified in part A of the first, which is, my lord, coal and lignite. That's only the two fuel minerals. Minerals specified in part B of the first schedule, your lordship may be pleased to note that this is only the atomic minerals. Other than that, everything is covered. And then land in respect to which minerals do not vest in the government. So that is still maintained. Now, where the government land is concerned, see now the qualitative change which has come. First, my lord, the state has to notify the areas for grant of lease. That's in subsection 3. In areas where the existence of mineral content of any notified mineral is established in the manner prescribed by the central government, the state government shall notify the area for grant of mining lease for such notified mineral in terms and conditions subject to which mining leases shall be granted, and any other relevant conditions as may be prescribed by the central government. So this continues now, as may be prescribed by the central government. The provisos are not relevant for us for the present. Subsection 4. For the purpose of granting a mining lease in respect of any notified mineral in the notified area, state government shall select through auction by a method of competitive bidding, including e-auction, an applicant who fulfills, and then the criteria is given. What is important is 5. The central government shall prescribe the terms and conditions and the procedure subject to which the auction will be conducted, including the bidding parameters. So everything which the state does is as per prescribed by the center and under the authority of the center. And any mineral rights now are created by this process. Just for the record, 11A is mineral rights for coal and lignite. We don't need to see the details. Section 13, page 958, read with the definition of mineral concession. So, a definition is now inserted. Okay, 3A. Section 3, 922. 3AE is the definition of mineral concession. Which means either reconnaissance permit, prospecting license, mining lease, composite license. So now, my lord, we have this umbrella expression, mineral concession. In section 13, it says the central government may by notification in the official gazette make rules for regulating the grant of mineral concession. Earlier, my lord, we had this reconnaissance permit, prospecting license, mining lease. They have now coined this expression mineral concession, an umbrella expression, and said mineral concession in respect to minerals and the purposes connected therewith. In Malad 13, just see one or two things, Malad. The Lordships don't mind. In subsection 2, F, the procedure for obtaining a mineral concession in respect of any land in which the minerals vest in a person other than the government, and the terms on which, the conditions subject to which a permanent license or lease may be granted or reduced. So now, Malad, this is made much more stricter. And my lord, just below that, fixing and collection of fees for mineral concession, surface rent, security deposit, fines or other fees or charges, and the time within which and the manner in which dead rent or royalty shall be payable. So even that is now done by the central government by rules. And just for completeness,
The state executes the lease deed. Is there any other form under the 1957 Act where a private person can execute?
K. No,
Form
form is
K.
the same. Form is the same. K. Because even the 57 Act, the only thing is the royalty goes to a private person.
Private person.
But otherwise, everything is controlled completely.
Because under that, the rents and royalties are reserved under the lease deed.
Yes.
But there are no other reservations made under that,
No.
such as this, what you said, 9B and 9C, where a percentage of the royalty has to be paid. They are not reserved under the lease deed.
I'll just check that one. 1 minute, please.
Incorporated,
But what is important is the ground reality is the major minerals. I don't think there are any private interests which really remain. The Check. Check, check.
Shall we go now to the case law or?
But I have a few more sections to show. Then what I call the trilogy.
Yes.
Engage, Tulak, Vaishnav.
Which is the Trinity?
Hingir,
Hingir,
Tulak,
Tulak.
and Vaishnav. That's why I said no need to reinvent the wheel. The interplay between 23 and 54 and how cesses fit or don't fit has been really well discussed. There are one or two cases which I'll have to deal with.
मेरी किताब खत्म होने जा रही है.
The section we need to show. So, my lord, and I say so candidly, in no case has there been, I mean, it may have been submitted to the court, but in no case will your lordship find a full discussion of 50. 23 and 54 have been discussed, and they do cast a shadow on 50. And there is a connection, which your lordship will see when I come. But in no case, this is the first time your lordship, and I am inviting your lordships to focus on 50 and interpret 50. But that discussion your lordship will not find. But after the trilogy of cases, there have been one or two others which I need to explain. One is that Chamanmal and the other is the Western Coalfield Act, which analyzes all this and deals with it. I want to argue my case without citing either India Cements or Kesara. None of your lordships hearing, but I do propose to deal with India Cements after I finish first principles analysis. Now, I had finished showing almost all the provisions, just one or two.
Even if we come to the conclusion that in paragraph 34, there is an obvious error. We are a bench of 9, so anyway, we have to.
Neither way, Malad, it turns whether there is an error, whether there is not.
We have to look at it as a matter of
first principles. And I start by saying the only real assistance your lordship.
Unless we, of course, come to the conclusion that India Cement, which is what they will argue, have been arguing, that India Cement as interpreted in Kesharam does reflect the correct position of law.
Malad,
But then to decide that again, we have to decide it
again. Exactly, I have to criticize Kesharam's reasoning. If your lordship say no, I'm wrong in Kesharam and our submissions are wrong, Kesharam is right, that's the end of the matter,
right.
Or vice versa. So, but this whether Kesharam should have done this to India Cement or done that to India Cement, frankly, I don't think it's a very useful way of addressing the problem. And I start by saying, Madam, in none of these cases will your lordship find a rigorous analysis of two propositions. What really is the meaning of 50? And the different mantras, if I may borrow the Chief Justice's phrase.
Yes.
And the second, your lordship will not find in any of the cases is a rigorous analysis of 49 and 50. The special excluding the general, is it a carve out? Is it not a carve out? Everybody has said, okay, 15 on there, 49 is there. But can 49 operate on minerals in respect of 50? And the third, Malad, which needs a little clarification, the Ralia Ram principle, measure, was Malad for the first time, if one may say so, contained and clarified, not in Bombay Tires, in RR Engineering.
The
Yes. where your lordship said, yes, but you have to remember it is only a measure, don't make it a tax. And excessive levy starts then affecting not just the measure, but it starts affecting the tax itself. That's the first time your lordship administered that caution. Bombay Tires brought it back. And there are one or two recent cases where Acer, your lordship struck down, saying you can't include a non-dutiable item in a measure, and how that will play out in our case. So, but these are the three broad areas which your lordship will have to consider. And none of this your lordship will find as a has been analyzed. I start by saying in the judgment in our favor, India Cement, or in Keswara, the judgment against us. So really, it's for your lordships to not consider all these aspects and come to a conclusion one way or the other. But I had almost finished there. One or two new provisions. One at section 17, which only show now the overriding powers. They added now section 17, which applies to all areas which vest in the government of a state or any other person, and give the central government the power to undertake reconnaissance, prospecting, and mining operations, and then they have to pay something. Details are not necessary, Manoj.
Yes.
And Manoj, since your lordships have mentioned this, I must point out, and I don't need to read the section, section 18, conservation and systematic development of minerals. Now there is an express provision. Something, Manoj, which is relevant to the entry 54 versus entry 23 discussion is section 20 capital A. Again, a newly added provision. This was added in 2015. Which says, notwithstanding anything contained, central government may issue such directions to the state as may be required for the conservation of mineral resources or any policy matter in the national interest and for scientific sustainable development. Now, my lord, 21 has one addition. Your lordship saw 21 of the act as originally brought in. Please see 21 now. It says whoever contravenes the provisions of subsection 1 or 1A of 4 shall be punishable with an imprisonment which may extend to 5 years. Your lordship saw section 4(1)A at page 925, where transporting. So if you even move it without paying royalty, it is now an expressly provided for criminal offense under 21. And we still have section 25. Malad, there are policing provisions like the power to search and the power of the state government to make rules for illegal mining, etc. in 23 capital B, 23 capital C. And there again, the state acts under a union legislation. And then we have 25. Say 24 is the power of inspection, etc., which is there earlier also. And then we have 25 continues. Any rent, royalty, fee, tax, fee, or other sum due to the government under this act or the rules made thereunder under terms and conditions of any mineral concession beyond the certificate of the officer as may be specified by the state government. In this behalf by general special order be recovered in the same way as land revenue. So, my lord, these are all statutory now, all statutory dues and liable to recovery in this fashion. Three one. And again, my lord, section 31 has the power of central government now has been given a power to relax any of the rules in the interest of mineral develop. So, well, that's how the law is. It's spread wider. Yes, one last thing which remained, Manoj, I need to show your lordship the auction rules, one or two provisions, to show how now the state, how the mineral rights are transferred. So that will be another aspect of the discussion now on tax on mineral rights. Marat, volume 4, page 2176. Marat. Your lordship will find the mineral auction rules 2015.
Page 2.
2176.
Four.
Four. Just one or two rules, Amalan, what your lordship needs to see, because the details are not necessary. Rule 8. Rule 8. Bidding parameters. The state government shall specify in the tender document the minimum percentage of the value of mineral dispatched. Please mark that. Have some bearing on it. Which shall be known as the reserve price. The value of the mineral dispatch shall be an amount equal to the product of the mineral dispatch in a month, the sale price, grade-wise by the Indian Bureau of Mines. And the bidder shall quote, as per the bidding parameter for the purpose of payment to the state government, a percentage of the value of the mineral dispatched equal to or above the reserve price. And the successful bidder shall pay to the state government an amount equal to the percentage so quoted in the value of mineral dispatch. This is how mineral rights are now created.
The expression mineral development in entry 50 of list 2, can it not be related to only section 18 of the 1957 Act?
My submission is going to be that these are not terms of art. Conservation of minerals is a integral part of mineral development. If you waste them, how are you going to develop? So the question is where is the emphasis? Earlier, we believed only in regulating, let people do what they did when it was considered a private resource. With the change in emphasis, where we treat this now as a national resource. This is the change in our thinking which has come. Now development comes ahead of regulation. Development is important. Regulating it is an integral part of development.
So
So
therefore,
development is a larger, if one may say so, the larger field, which means you regulate how it is processed, how it is progressed. Sometimes it is necessary not to allow removal in order to make sure that you get the maximum possible benefit of the mineral resource without compromising other factors, but not things which we never did. Your question is very important. Things which we never did, we do today. And it started with environment law. It's now come into this law. You have to do what is called a cost benefit analysis. what is the cost of the activity? So today we look at life very differently. What is the cost benefit analysis of mineral development? You're taking the mineral out. It's value addition. So if you're taking coal out, the value of coal in generating electricity and that electricity used to say manufacture aluminum, used to manufacture steel, etc., etc. So that's the value chain. That's the benefit. What's the cost? The cost is degradation of land, degradation of forests, human displacement. All this comes in the cost. And it's only when the benefits outstrip the cost. Now that is the new mantra of development. So now when we talk of mineral development, we talk of it very differently, from very different lenses. Then we thought in the days of the crown where development basically meant running away with whatever you could lay your hands on.
So only the limitation is with regard to mineral development.
But it's only mineral development is pretty much everything.
Correct, but then before imposing a tax, then the state has to see whether there is any limitation imposed by parliament by law on mineral development,
Correct.
which is traceable to
54.
50, no, and section 18 particularly of the act.
Of course.
It
18
gives
no, not-
various
sorry,
aspects.
Not only 18, the entirety of the act. Correct. I'm going to make that true. The entirety, there are so many other provisions in the act. 18 is a part of a larger, the entry 50 is not to be so narrowly construed. It's going to be massive because they are legislative entries. Your lordships have always held legislative entries have to be construed broadly. Today it's 18, tomorrow it may be something more, something less. The ambit of the entries has to be seen as the entries play with each other and how they interface. What I propose to do after I give the trilogy of cases, explain the one or two other cases, then I propose to address the court on an area which in one sense is untraversed so far. A rigorous analysis of entry 50 and how it plays out with entry 23 and entry 54. But ultimately, the answer to the question which this court is dealing with today in this reference will depend on 50 and the limits of 50. So I've shown rule 8. And then there is a whole detail of how bidding process has to be done. And then the mining lease is to be granted. Important to show that today it is by statute that in order to obtain mineral rights, another aspect of this will be the state taxing rights created under a union legislation. So that will have some bearing. It's one thing where a private lessee creates, a private owner creates rights, but where a state itself has created rights as a facet of mineral development, can you tax those rights? Is going to be one aspect of entry.
When the center is created.
Yes, under a central legislation. The state may be acting under the central law, but when the center is creating these rights. And that's what the court will have to see. To what extent, if 23, as the trilogy of cases says, is virtually gone, it's now all entry 54. Then the creation of these rights, where do you find these rights? Do I find them in 54? Do I find them in the state? Do I find them in the sovereign ownership of the state, or do I find them in law? But that will become an important element in the analysis of entry 50. That's why I'm showing all these provisions. Now, Malad, with this, may I? Yes, one last thing, Malad, the national mineral policy, then we are done with this. It's a 2019 policy. Page 2319. 2319. I just wanted to show para 3. The core of the functions of state in mining. And this is under the heading of mineral development, only to show that the word mineral development has a much wider sweep. The core of the state in mining will be facilitation and regulation of exploration.
Where do we read, Mr. Sarin? 232?
I'm sorry, my lord, 232. My mistake. Yes. So this is only to show that mineral development includes regulation. That's all, even in the policy. And I'm so sorry.
But
And just one thing, Manoj, and then I'm done with this. Responding to my lady's observation, please see section 13 of the Act. I've shown this earlier. Now, this comes under the heading of regulation. And in the regulation head, we have 13 to F. I had already shown this, 13 to F and 13 to I, which includes fixing and collection of fees, rent, security, royalty, and the payment to district fund, payment to this fund, payment to that fund. So regulation and development are overlapping concepts. In fact, development is the larger concept, which it takes in regulation.
That is only with regard to.
Shown on. Now, my lord, may I now, my lord, move quickly ahead? My lord, this policy is there, your lordships will see it. The trilogy, my lord. 61 to SCR 537 is Ringgit Rampo. And this is in all these three judgments, my lord, to be can be found in volume 5. It begins at page 142 of volume 5. The first paragraph gives the details. There were 2 leases. And para 2 is interesting. This will be a part of our submissions, especially when we deal with entry 49. Pursuant to section 5 of the Orissa Estates Abolition Act, all the right, title and interest of the Zamindar of Rampo in the lands demised to the first petitioner under the second lease vested in respondent 1, the state of Orissa. In fact, state by state, this is how the state became the owner of the minerals. Since the first petitioner has duly paid the rent reserved by the lease to the appropriate authorities and observed performed all the covenants. And interestingly, all these abolition acts, when they were challenged, they were upheld not under entry 23. They were all upheld under the power of acquisition for the state. Then, my lord, the details are given about the rules where a cess was imposed. And page 144, para 6, your lordship will find the challenge. The petitioners contain impugned act and rules are ultra vires the powers of the legislature, and any event repugnant to the provisions of the existing law. According to the petition, the cess levied under the impugned act is not a fee, but in reality a levy in the nature of duty of excise on the coal produced at the first petitioner's Rampol colliery and belongs so on. So alternatively, it is urged. In fact, but the first contention is relevant because this is what led to Justice Vanchu's dissent, which has created some confusion in India Cement. So the first contention was that excise duty. Second was alternatively it is urged that even if the levy imposes a fee relatable to entry 23 and 66 of the 7th schedule, it would nevertheless be ultra vires having regard to the provisions of 54 and list 1 read with the Central Act 53 of 1948. This contention, your lordship may mark, because this is really what we are concerned with. The petitioner further alleged even if the levy is a fee, it would be similarly ultra vires having regard to entry 52 and list 1, etc. Now, my lord, the discussion as far as the present case is concerned, what is relevant is from para 16 only to show what the act is. At page 149. Let us now examine the scheme of the Impugned Act. As the preamble shows, it has been passed because it was thought expedient to constitute mining areas and a mining areas development fund in the state of Orissa. It has 11 sections. Section 3 provides for the constitution of a mining area wherever it appears necessary for the state, is necessary and expedient to provide for amenities like communication, water supply, electricity for the better development of the area in the state of Orissa, wherein any mine is situated, or to provide for so on. So, and these are not the general mining area provisions. Para 17 at page 150. The scheme of the Act thus clearly shows it's been passed for development of mining areas in the state. The basis for the operation is the constitution of a mining area, and it is in regard to mining areas thus constituted that the provision of the Act come into play. It is not difficult to appreciate the intention of the state legislature evidenced by this Act. Orissa is an underdeveloped state in the union, though it has a lot of mineral wealth of great potential value. Unfortunately, its mineral wealth is located generally in areas sparsely populated with bad communications. Inevitably, the exploitation of the minerals is handicapped by lack of communication and the difficulty experienced in keeping labor force sufficiently healthy. Mineral development therefore requires provision should be made for improving communications by constructing good roads. Now, this is important because the development itself requires regulation of activities and preservation. The discussion first part relates to whether it's a duty of excise. That begins at para 20. It's only necessary because otherwise the Justice Vanchu dissent and mineral rights doesn't become clear. Para 20 notes the contention. It is, however, urged that the cess levied by 4.2 is in substance and reality a duty of excise. As we have already noticed, 4.2 provides that the rate of levy shall not exceed 5% of the valuation of the mineral at pit's mouth. In other words, it's the value of the minerals produced, which is the basis for calculating the cess payable by mine owners. And that precisely is the nature in which the duty of excise is levied. The interim powers Parliament to impose duties of excise inter alia on goods manufactured when minerals are produced, etc., etc. When the minerals are produced from mines and excise is intended to be imposed on them, it would normally be imposed at pit's mouth, and that is precisely what the Impugned Act purports to do. It's also contended that the rate under 4.2 indicates it must operate not merely as a fee but a duty of excise. That was the contention. The argument will be carefully examined before the character of the cess is determined. It is not disputed that under entry 23 in list 2 with entry 66, the legislature can levy a fee in respect of mines and mineral development. Entry 23 reads thus, then the entry is set out. We will deal with the condition imposed by the latter part of this entry later. For the present, it is enough to state that the regulation of mines and mineral development is within the competence of the state legislature. 66 provides that fees in respect to the matters in the said list can be imposed by the state, subject, of course, to the exception of fees taken by the court. The argument is, though the legislature is competent to levy a fee of mines and mineral, if the statute passed in substance and effect imposes a duty of excise that is traveling outside the jurisdiction and is trespassing on the legislative powers of parliament. The argument is based on two considerations. The first relates to the form in which the levy is imposed, and the second relates to the extent of the levy authorized. The extent would always depend on the nature of services intended to be rendered and the financial obligations. If the services intended to be rendered to the notified mineral heirs require that a fairly large cess should be collected, and the correlation can be definitely established between the proposed services and the impost, it would be unreasonable to suggest that because the rate of the levy is high, it is not a fee but a duty of excise. In the present case, if the development of mining areas involves considerable expenditure, which necessitates the levy of the prescribed rate, it only means that the services being rendered to the mining areas are very valuable, and the ratepayer in substance is compensating the state for services rendered by him. It is significant petitioners do not seriously suggest that the services intended are a cloak and not genuine, or that the taxes have no relation to the services, or they are unreasonable and excessive. Therefore, in our opinion, the rate, the extent of the rate allowed to be imposed by 4.2 cannot by itself alter the character of the levy from a fee into that of the duty of excise. If the correlation between the levy and services was not genuine or real, or if the levy was disproportionately higher than the requirement of the services intended to be rendered, it would have been another matter. Then, as to the form in which the impost is levied, difficult to appreciate how the method adopted by the legislature in recovering the impost can alter its character. The character of the levy must be determined in the light of the test we have referred. The method in which the fee is recovered is a matter of convenience, and it by itself cannot fix upon the levy the character of the duty of excise. It has often been considered in the past, it's always been held that the method in which it is levied may be relevant in determining the character, significance, and offense cannot be exaggerated. Then, Malad, all these classic cases are cited and propose to read these, Malad. This Ralaram, Malad, is, and then Bairamji Jijiboy. Then, Malad, in the next para is the Governor General Council, Province of Madras. I will, Malad, deal with them when I deal with Bombay Tire, which, and those cases, and RR Engineering. So, Malad, if I don't want to take up time here reading these cases. 24 onwards is the discussion where it goes into this entry 54 and entry 23. And this is important because, Malad, here they upheld it only on one ground. They said the declaration has to be post 1950. The 48 Act declaration doesn't deal you. Otherwise, they said it's a complete sweep. Please see para 24 onwards. The next question which arises is, even if the cess is a fee, and as such may be relatable to 23 and 66, is validity is still open to challenge because the legislative competence of the state legislature under entry 23 is subject to the provisions of list 1 with respect to regulation and development under the control of union. And that takes us to entry 54 in list 1. This entry reads thus. Then, Malad, the entry is set out. The effect, reading the two entries together, is clear. The jurisdiction of the state legislature under entry 23 is subject to the limitation imposed by the latter part of the entry. If Parliament, by its law, has declared that the regulation and development of mines should in public interest be under the control of the union, to the extent of such declaration, the jurisdiction of the state legislature is excluded. Please mark the words "to the extent of the declaration." In other words, if a central act has been passed, which contains a declaration by Parliament as required by entry 54, and if the declaration covers the field occupied by the impugned act, the impugned act would be ultra vires, not because of any repugnance between the two statutes, but because the state legislature had no jurisdiction to pass the law. The limitation imposed by latter part of entry 23 is a limitation on the legislative competence of the state itself. This position is not in dispute. This is extremely important, this principle. So it's not a do-don't kind of repugnance that I must show a section in the Union Act which stops or which runs counter to a provision in the State Act for the State Act to pay.
In this paragraph, they don't discuss entry 50.
Because they were not concerned with 50. It was because they held it's a fee.
It's a
The
fee.
fee means 23. And here they said, but for the fact that the declaration under 48 Act is not good enough, we have to struck the fees down.
So till 1957 Act came, they could do it.
Till the
States had the freedom.
And that's why in the next two cases, Tulak in this, it was struck down. But this principle was, everybody reaches back to Hinker and said principle was settled in that case. See, the next para also is relevant. It is urged by Mr. Amin that the field covered by the Impugned Act has already been covered by the MMRD Act 1948, and he contends that in view of the declaration made by under Section 2 of the Impugned Act is in the declaration of the 2 of the Impugned Act is ultra vires. Just 1 minute. This thing has gone away. 155, yes. The Central Act was passed to provide for the regulation of mines and oil fields for the development. It may be stated at this stage that Act 67 of 57, which has been subsequently passed by Parliament, Act 53 of 48 has now been limited only to oil fields. They are, however, concerned with the operation of the Act in 52, and at that time applied to mines as well as oil fields. Section 2 of the Act contains the declaration to the expediency and control by the central government. It reads thus, then the declaration, etc. It is common ground that at the relevant time, this Act applied to coal mines. Section 4 of the Act provides that no mining lease shall be granted after the commencement of this Act, otherwise than in accordance with the rules made under the Act. Section 5 empowers the central government to make rules by notification regulating the grant of mining leases or for prohibiting the grant of such leases in respect of any mineral or any area. Section 4 and 5 thus purport to prescribe necessary conditions in accordance with the mining leases have to be executed. This part of this Act has no relevance to our present purpose. Section 6 of the Act, however, empowers the central government to make rules by notification in the official gazette for the conservation and development of minerals. 6.2 lays down several matters in respect of which rules can be framed by the central government. This power is, however, without prejudice to the generality of the powers conferred on the government by 6.1. Amongst the matters by 6.2 is the levy and collection of royalties, fees or taxes in respect of minerals mined, quarried, excavated or collected. It is true that no rules have in fact been framed by the central government in regard to the levy and collection of any fees. But in our opinion, that would not make any difference. If it is held that the Act contains the declaration referred to entry 23, there would be no difficulty in holding that the declaration covers the field of conservation and development of minerals, and the said field is indistinguishable from the field covered by the Impugned Act. What entry 23 provides is that the legislative competence of the state legislature is subject to the provisions of List 1 with respect to the regulation and development under the control of the Union. And entry 54 on List 1 requires a declaration by Parliament by law that the regulation and development of mines should be under the control of the Union in public interest. Therefore, if a central act has been passed for the purpose of providing for conservation and development of minerals, and if it contains the requisite declaration, it would not be competent for the state legislature to pass an act in respect of the subject matter covered by the declaration. So it's not a section by section measure. The field is occupied and it is displaced from the state's list. In order that the declaration should be effective, it is not necessary that the rule should be made or enforced. All that is required is a declaration by Parliament that it is expedient in the public interest to take the regulation and development of mines under the control of the Union. In such a case, the test must be whether the legislative declaration covers the field or not. Judged by this test, there can be no doubt that the field covered by the impugned act is covered by the Central Act of 1948. I mean, just pause here for a minute. This is very important for the building block of my submissions. The 48 Act, and that's why I trouble your lordship seeing it in some detail, unlike the 57 Act, had no provisions beyond saying the center may make rules, the state may make rules. That's all that it did. The center may make rules for the following, the state may make rules for the following. And the argument was, but there are no rules. And this court said, doesn't matter, all we need to look at the declaration. If the declaration is there, 23 then stands denuded.
But it is only to the extent.
That is not what the law is.
No, but
Correct, but that's not how it is construed. And I'll come to that. It is not section by section. If the subject matter is occupied.
to the extent. That is what entry.
If I may just digress. In fact, the interpretation placed. Extent is not by the number of sections or the points covered. Yes. And the declaration has been understood very widely because the declaration now is the regulation and development of minerals. And that's how this court has always understood the declaration to be. Not by an individual rule or by a subsection or by a section.
Then what is the meaning to be given to the expression to the extent to which such declaration is made by Parliament by law to be expedient with the public interest?
Parliament could have made a lesser declaration. But the section 2 declaration says it is hereby declared that the development and regulation of mines is in the interest, public interest in the Union. Finished.
Entire,
Gone.
so you're saying the entire development and entire regulation. Regulation is a part of development.
Correct. In other words, the entry said we will leave it to Parliament to define the extent. What this judgment is based is on the declaration. If your ladyship turns back for a second, the declaration is set out
Yes.
at page 155. The last few lines of 155. It is hereby declared that it is expedient in the public interest that the central government should take under its control the regulation and development of mines and oil fields and the development of the minerals to the extent hereinafter provided. And all the rules for granting lease, this, that, everything goes.
But it's the section 2 says to the extent hereinafter
And
provided.
Correct, and there was nothing there, there's nothing left because that's why I showed all the sections, right from the time of considering, notifying minerals, grant of leases, imposition of royalties, checking, safeguards, search, this form, you will do it in this form, the form will say like this is the lease you will execute, nothing is left.
There could be something beyond that. Beyond what is
Nobody has
expressly
anything.
declared.
And the development of mineral areas.
Mr. Salve, actually, they were construing the relationship between entry 54 of list 1 and entry 23 of list 2.
That's right.
The reference to declaration is contained in
23.
entry 54. Entry 54
Entry
of list
54,
1.
yes, sorry, yes.
Once that declaration is made, because entry 54 is conditional, regulation and development, regulation of mines and mineral development, to the extent to which such regulation or development under the control of the Union is declared by Parliament by law to be expedient. So
Correct.
declaration comes under entry 54.
Entry 54.
That declaration is contained in 2. Once the declaration is made under entry 54,
23 is out.
then 23 is out. So really speaking, they were considering the relationship between entry 23 and entry 54. It had
Correct.
nothing to do as such with the tax, because here was a fee.
My lord, how this impacts, this does
This fee didn't
impact.
come up at all.
My lord, this does impact. When I come to my analysis of 50, I will, because 50 also is subject to law relating to mineral development. For the present, I'm only,
Limitations by law.
I agree, accept that, my lord, completely accept it. But if your lordship don't, I'll come to 50 in a moment. For the present, I wanted to clear one ground. This is not a section by section analysis. Your lordship's question to me was very
To the
important.
extent provided here in.
What is the
our-
meaning of to the extent provided? That has been interpreted.
Entry 23 by itself is made subordinate to a declaration, to entry 54 of list 1. So because it says subject to the provisions of list 1, subject to the provisions of list 1 with
Yes.
respect to regulation and development under the control of the union.
Yes.
So the entirety of entry 23 is subordinate to entry
Subordinated.
54
That's
entry 54 of list
It is not quantitative.
Right. Once a declaration is made, then the test, as Justice Gandakarkar says, is the subject of the state act.
Subject.
Does it cover a field covered by the declaration?
That's
Now,
the point
but-
which I was
but-
trying to.
But that subordination is not there insofar as entry 50 is.
No, it's
concerned.
not. In fact, I'm sorry.
Entry 50 is, it's restricted by the limitations which are imposed.
Malad, I'm sorry. As I said in the morning, Malad, my submission is based not on the principle of subordination, because 50 is a very different mantra from 54.
Right.
I was first at the building block of my submissions. One of the questions which arose, and my learned friend said is, and Mr. Dwivedi repeatedly emphasized the word to the extent, to the extent. That's not how it was understood. It is the subject matter test which applies.
But in what context?
No, in 50,
The
54.
subject matter test squarely because entry 23 is subordinate to entry 54. Once a declaration is made in a law which is enacted with reference to entry 54, then the state law cannot occupy the same field.
Malad, that's the first step of my submission.
Right.
And
That has absolutely no bearing on the taxing provision. The taxing
whether it does
legislation.
or does not,
That's right. Because entry 50 is completely, while crafting entry 50 of list 2, they could have said subject to the provisions of list 1.
no, it could have been much narrower.
Regulation and
On
development.
the contrary, it would have been narrower. My submission is going to be the words of limitation today are wider than the earlier. Because, my lord, the two concepts are very different. In fact, what my lord, the Chief Justice is saying is exactly the point which I'm relying on. This is 50 has a very different construct. First, my lord, I want to fix where do the mineral rights source from today? And for that, because what is the tax on mineral rights? You have to first
In
get.
fact, entry 50 itself militates against the doctrine of occupied field because it says subject to limitations imposed by law by parliament.
Yes.
So when it says limitations imposed by law, it necessarily means that the law must engraft certain limitations which will operate as a restraint on the taxing power.
I'm not completely in with.
Not by inference and not by
No,
the
no, no,
doctrine
no,
of
no.
occupied
No.
field.
Malad, I'm sorry. I'm on the contrary. As I said, Malad, there are 3 or 4 kinds. There are some which are shared. There are some which are occupied. 50 stands in a class by itself. I have not found any other entry like 50. What are the contours of 50? I am going to come to, but Malad, to get to 50. One of the points made, and I was getting past those because there are 3 judgments on this. And this has a direct bearing on entry 4950, which is one of the important points of Kesaram I have to deal with. I was only not putting across the point that it is a subject matter test which applies to 54 with 23.
Right. 23 and 54 because of the relationship between the two
Yes.
entities actually.
That's all that I wanted to show, Marat.
Yes.
And that discussion is very important because how that impacts 50. Yeah, I continue.
Yes.
Responding to your ladyship's question, the expression to the extent hereinafter provided has been understood as a concept of subject matter, not of specific provisions of the Act. And if I may just show that again, that's the discussion made, which I was just reading at page 155. In the middle of para 24, the jurisdiction of the legislature under entry 23 is subject to the limitation imposed if Parliament by its law has declared that the regulation and development of mines should be in public interest, should be in the control of the Union to the extent such declaration, to the extent of such declaration,
Yes.
the jurisdiction of the state legislature is excluded to the extent of the declaration, not the specific provisions. Now the declaration is unconditional.
But in this paragraph 24, there is no reference to the extent hereinafter.
It is to the extent of the declaration.
They were dealing with not the 1957 Act. They were dealing with the 1948 Act.
Yes, but the language is the same. Exactly the same language. In fact, it is set out. The declaration is quoted. No, I just read it. It's there in the judgment. Para 25, please see para 25 again. If I read it a little slowly, the discussion will become clear.
About 7 lines from the bottom.
Yes.
Yes.
It is hereby declared that it is in the expedient and in the public interest that the central government should take under its control the regulation of mines and oil fields and the development of minerals to the extent hereinafter provided. Exactly the same declaration. It is common ground. It is common ground that at the relevant time, this act applied to coal mines. So you have to see in that context. Section 4 provides that no mining lease shall be granted after the commencement in accordance with the rules. And Section 5 empowers the government to make the rules by notification for regulating the grant of mineral leases or for prohibiting the grant, etc. Section 4 and 5 thus purport to prescribe necessary condition in accordance with which mining leases have to be executed. This part of the Act has no relevance for our present purpose. Section 6, however, empowers the government to, by rules, by notification in the Gazette for the conservation and development of minerals. 6.2 lays down several matters in respect of which rules can be framed. This power is, however, without prejudice to the generality of the powers conferred on the central government under 6.1. Amongst the matters covered by 6.2 is the levy and collection of royalties, fees, taxes in respect of minerals mined, quarried, excavated, and collected. It is true that no rules have in fact been framed by the government in regard to the levy and collection, but in our opinion, that would make no difference. If it is held that the Act contains the declaration referred to in entry 23, there would be no difficulty in holding that the declaration covers the field of conservation and development of minerals. So the cover is of the field, legislative field. And the said field is indistinguishable from the field covered by the impugned Act. And I submit that position, in fact, stands strengthened rather than weakened by the 57 Act. 57 is much wider than the 48 Act. So in that way, the extent is dealt with. And broadly, the grant of, right from birth to death,
Yes.
the grant of lease, license, fees, how you apply, what you do, how you run a lease, and the absolute power to frame rules, including the state government is given power by a union. So the field is occupied. And once that field is occupied, the declaration denotes entry 23. I'm not saying it denotes 50. I'm saying it denotes 23. Then para 26, it says, still remains to be considered whether 2 of the Act amounts to a declaration as required by Article 54. When the Act was passed in 48, legislative powers of the central and provincial legislatures were governed by the relevant entries in the 7th schedule. Entry 36 in List 1 corresponds to entry 54 in List 1. It reads thus, and then that entry is set out. It would be noticed that the declaration required by entry 36 is a declaration by dominion law. Referring to section 2, it is clear that the declaration contained in this section is put in a passive voice, but in the context, there would be no difficulty in holding that the declaration by necessary implication has been made by dominion law. It's a declaration contained in the section passed by dominion legislature, and it is obvious a declaration by dominion law. When a declaration by dominion law be constitutionally a declaration by parliament under entry 54, and this was said it is not. That reasoning is not relevant for us today. So what says that declaration under dominion legislation doesn't help. Para 36 at page 161. There's one more point which is yet to be considered. Mr. Amin contends that entry 23 in list 2 is subject to the provisions in list 1 with respect to the regulation and development under the controls of union. And according to him, entry 52 in list 1 is one such provision. In this connection, he relies on the entry which deals with industries, the control of which by the union is declared by parliament to be expedient in public interest. This act has been passed to provide for development and regulation of certain industries, one of which is undoubtedly a coal mining industry. Section 2 of the act declares it is expedient in the public interest that the union should take under the control industries specified in the first schedule. This declaration is the declaration made by parliament, and if the provisions are to be read with the declaration covered by the same field is covered by the impugned act, it would undoubtedly affect the virus of the act. But in dealing with the question, it's important to bear in mind the doctrine of pith and substance. You've already noticed that in pith and substance, the impugned act is concerned with the development of mining areas notified under it. The Central Act, on the other hand, deals more directly with the control of all industries in the course of industry of coal. I'm so sorry about that. This discussion is a little important because entry 23, there is also an eclipse by 52. Could be. One is directly 54 versus 23. Now, the interplay of 52 and 23, this is the only judgment which deals with. And it says if the subject matter is the same, of course, even that declaration would affect 23. But then they say by pith and substance, this is from development of mining areas that deals with industry, and therefore the two don't overlap. On that basis, this act is upheld. The majority, number of this comes closer home, page 162. PC para 37. Our conclusion is that the impugned act is relatable to entries 23 and 66 of list 2 of the 7th schedule. Validity is not impaired and affected by 52 and 54 of list 1, read with Act 65 and 53. In view of this conclusion, it is unnecessary to consider whether the impugned act can be justified under entry 50 of list 2. Whether it is relatable to 24 of list 3 and suffers from the vice of repugnancy. The result is petition fails. So this judgment primarily went on the basis, it's a fee. There is no declaration in the 48 Act which denotes, therefore sustains. It notices 52 could have overshadowed, but it says the subject matter of 52 is different.
So they didn't deal with entry 50 list 2 as such.
They did. Justice Vanchu deals with it. And Justice Vanchu's dissent is considered in India Cement and criticized. And that sentence criticizing his reasoning, it doesn't say so and so. When I read India Cements, I'll explain, is considered to be a mistake. That how could India Cement say in one place royalty is not a tax, one place royalty is a tax? Vanchu J starts at page 162. At page 163, para 42, he tees up the first issue about tax and fee. I won't trouble your lordship reading that discussion. His lordship says, in principle, there's no difference between tax and fee. And then at page 166, para 46, let me then look at the pith and substance of the cess which has been imposed. The cess consists of a levy not exceeding 5% of the value of mineral of the pit's mouth. Prima facie, such a levy is nothing more or nothing less than a duty of excise. Entry 84 of List 1 gives power to levy duties. And then he sets out entry 84, then the famous Governor General and Council in Province of Madras. And I don't need to trouble the court with the line of reasoning he follows. He comes to the conclusion at page 171, para 52. He starts analyzing the law. And the last three lines of para 52, looking at that, at page 172, the lordship said, I don't want to read the whole para because we're not really concerned with the reasoning. Looking at that, the cess in this case is in pith and substance, nothing other than a duty of excise under entry 84, and therefore legislature was incompetent to levy it as a fee. So, what turned with him was that this was a tax on production or manufacture because it was on the mineral removed. Then he gets into, because of the view he took, then he had to consider the alternative submission of entry 50. And that discussion is on para 53. Right. The next contention on behalf of state of Orissa is the cess is not justified as a fee. It's a tax under item 50 of List 2 of the 7th schedule. 50 provides for taxes on mineral rights, subject to any limitations imposed by Parliament by law relating to mineral development. This raises the question as to what are taxes on mineral rights. Obviously, a tax on mineral rights was different from taxes on goods produced in the nature of duties of excise. If the tax on mineral rights also includes tax on minerals produced, there would be no difference between taxes on mineral rights and duties of excise. Now, pausing here for a minute, a royalty which is based on the quantity of mineral produced, then by this definition should be duty of excise. I'm not saying this is the correct definition, possibly it's wrong, because this confuses, this is missing the distinction between measure and subject matter. But his first part of his logic was that it must be different from a duty of excise. The difference can be understood if one sees that before minerals are extracted and become liable to duties of excise, somebody has got to work the mines. The usual method of working them is for the owner of the mine to grant mining lease to those who have got the capital to work the mines. There should be no difficulty in holding that taxes on mineral rights are the taxes on, please mark the words, the right to extract minerals, and not the taxes on the minerals actually extracted. Thus, taxes on mineral rights would be confined, for example, to taxes on leases of mineral rights, and on the premium or royalty for that, taxes on such premium and royalty would be a tax on mineral rights, whereas taxes on minerals actually extracted would be duty of excise. Now, the fallacy in this is the royalty itself is on extracted mineral. I mean, this whole line of reasoning with respect is wrong. with respect to Justice 1-2, and it is a minority. What India Cement said is, and with respect correctly says, that if a tax on extracted mineral is excise duty, then a tax on royalty can't be a tax on mineral. Because royalty itself is on extracted mineral. It is not on the right to extract a mineral. That is what India Cement said in this context.
The basis for levying royalty is on the mineral extracted.
Exactly. Now, if that, according to Justice 1-2's logic, is an excise duty, then royalty itself is an excise duty. Where are we getting with this? So, it is not, his first part of his reasoning is clearly minority, and with all respect to him, it is wrong. It's against the run of authority, before and after.
Should we go to the next authority now in the trilogy?
Yes. This is the only bit, and he's the only judge who has dealt with entry 50 ever. The next is Malat Talak, 64-4 SCR 461, and in this very bundle, your lordship will find it at 278.
64 for SCR.
461. All these SCRs are being put in soft form now.
And they're absolutely up to date.
Oh, I see.
And we now have not only the ESCR, which is in the PDF form, but DGSCR, which is like a book. You can have the joy of actually flipping the pages as well with the DGSCR.
78. Yes.
So really speaking, we have to go back to practice of citing SCRs.
But in
now.
this court, we never cited anything other than SCRs. Till the SCRs went off.
SCR was way behind schedule, almost 4 years behind schedule, but now it's absolutely up to date. And
By
we have
end
now
80s, it went off the rails.
DGSCR.
And we always found it makes much softer reading, the old SCRs.
Yes.
Broad print.
The print was much bigger and
They don't have panel on this.
Head notes were being by the honorable judges. So head notes are more.
More authentic.
Farmer.
That was the reason why this. That's what the kind of situation we came in India Cement with regard to the so-called error, printing error, etc. All this would not have happened if someone who had taken the trouble to looking at the parchment.
But it didn't have parameters, it was a big problem.
No, there was no parallel.
and we also have neutral citations now.
At that time, yes.
We used it forever.
We
but
should
I
be
don't
now
think there
using
was
neutral citations at all, because all of us should be using neutral citation, because now it's across the spectrum. Whatever journal you're citing, there's one neutral citation for all judgments from 1950.
You get it. But I'm sorry, I'm a little out of date.
You know, you as in the US reports, you have
Yes,
349 US
yes,
22.
always
So
cross-reference.
we have now neutral citation for every judgment of the Supreme Court from 1950.
Malad, this Angar J,
What page is it?
Malad, page 272. No, sorry, 278, my mistake. Now, this is Malad, a follow-up. The same Orissa Act, upheld by the court, was struck down by the High Court post 58. And that your lordship get at para 4. Shall now proceed to set out briefly the grounds on which the learned judges of the High Court allowed the petition of the respondents. Stated shortly, the contention which the learned judges of the High Court accepted was the Orissa Act has been rendered ineffective or suppressed, should be superseded by central enactment, the Mines and Minerals Act 57. Orissa Act had been enacted by virtue of 23 of List 1, which reads thus. The legislative entry under which the latter Central Act was enacted was 54, which ran thus. The Central Act carried in its second section a declaration envisaged by the last words of the entry. Based on these facts, the argument to which the learned judges acceded was that on coming into force of the Central Act, the Orissa Act ceased to be operative by reason of the withdrawal of the legislative competence by force of the entry of the state list being subject to parliamentary declaration and the law enacted by Parliament. They had that for this reason, the Orissa Act should be deemed to be non-existent as and from June 1st, 1958, and for every purpose with the consequence, there was lack of power to enforce and realize demands for the payment of fee at the time when the demands were issued. It's the correctness of the judgment challenge before us. Before proceeding further, it is necessary to specify briefly the legislative power on the relevant topic, for it is on the precise wording of entries in 7th schedule of the Constitution and scope and effect of the state and central legislation, which we have referred to. Article then 246(1) is set out, then 246(3) is set out, and just below that, it's coming now to the 7th schedule. Entry 13 of the state list vests in the state legislature the power to enact laws on the subject of regulation in mines and mineral development. This should be 23(1). Development subject to the provisions of List 1 with respect to regulation and development under the control of the Union. It would be seen that the subject to the provisions of List 1, the power of the state to enact legislation on the topics of mines and minerals development is plenary. The provision in List 1 is, as is already noticed in entry 54 of the Union list. May be mentioned that this scheme of the distribution of legislative power between the center and the states is not new, but merely a continuation of the state of affairs, which prevailed under the GOI Act 1935, which included a provision on the lines of entry 54 of the Union list, which then bore the number 36 of the Federal list, and an entry corresponding to entry 23 of the state list, which bore the same number in the provincial legislative list. There is no controversy that the Central Act had been enacted by Parliament and exercise of the legislative power contained in entry 54, or as regards Central Act, containing the declaration of what is required by entry 54 for it enacts in section 2, and then the declaration is set out. It does not need much argument to realize that to the extent to which the Union government has taken under its control the regulation and development of minerals, so much was withdrawn from the ambit of the power of the state legislature under entry 23, and the legislature of the state, which had rested on the existence of the power under the entry, would to the extent of the control be superseded or rendered ineffective. For here we have not a mere case, not of mere repugnancy between the provisions of the two enactments, but of a denudation or deprivation of states' legislative power by the declaration which Parliament is empowered to make and has made. It would be, however, apparent that the states would lose legislative competence only to the extent to which the regulation and development under the control of the Union has been declared by Parliament to be expedient in public interest. The crucial inquiry, therefore, has to be to ascertain this extent, for beyond it, the legislative of the power of the state remains unimpaired. As the legislation by the state in this case before earlier one in point of time, it would be logical to first analyze the State Act and determine its purpose, width, and scope, and the area of the operation, and to consider what extent the Central Act cuts into it or trenches into it. The object of the Orissa Act, as disclosed by its preamble, of the constitution of mining areas and the creation of a mining area development fund in the state. Section 3 empowers the state to constitute and alter the limit of the mining areas. The object of these mining areas was inter alia the provision of amenities like communications, water supply, electricity, and the better development of areas where any mine was situated, as well as to provide for the welfare of residents or the workers. 4 is the provision empowering the state to levy a cess or fee for all extracted minerals from any mines in any mining area, with a limit, however, that the rate should not exceed 5% of the value of the minerals. And then that section 5 is set out. Para 8 onwards is at page 281, foot of the page. We shall now turn to the Central Act. The long title of the Act specifies the twin purposes are the regulation of mines and the, just one minute, and the, yes, and the development of minerals. both under the control of the union. Section 2, we have already extracted. 3 contains definition of the terms and may be omitted. 4 to 10 form a group under general restrictions on undertaking, prospecting, and mining, and relate to the rules and regulations under which prospecting license and mining leases might be granted, the period for which they may be granted or renewed, the royalties and fees that would be payable. The next group consists of 10 to 12, which deals with procedure for obtaining prospecting licenses, the mining leases. 13 to 17 are grouped under the caption which reads rules for regulating the grant of prospecting license. 13, which starts empowering the government by notification to make rules for regulating the grant, etc. And then all these sections are done. Then comes section 18, which is the provision for other objects of the Act, the development of minerals. It will be necessary to set out some details, then 18 is set out. Para 9. The question for consideration is whether the extent of control and regulation by the Central Act takes within its fold the area subject to the EUROSA Act. Counsel for the appellant raised 4 points that the object of the Act. May I come straight to the discussion? The discussion starts from para 12, page 286.
Yes.
Before referring to the judgment dealing on this aspect, it would be convenient to refer to the Central Act of 48, on the basis of which the constitutional validity of the EUROSA Act is impugned. Then that act is set out. Mr. Justice Gajendra Garkar's judgment is set out, which I've just read, so I don't need to read it from here. Yes.
After the quotation.
Page 288, immediately after extracting it. It's only necessary to add the validity of the impost to the firm. However, for the reason whereas the EUROSA Act was a post-constitution enactment and the Central Act of 41 was a pre-constitution law in terms of entry 54, Parliament had not made the requisite declaration, but only the previously existing central legislature, it was held not within the meaning of 54, and the state enactment continued to be operative. Since the Central Act 67 contains the requisite declaration by Union Parliament under entry 54, and that act covers the same field as the Act of 48 in regard to the mines and minerals, we consider the decision of the court concludes the matter, unless there were any material differences between the scope and ambit of 54 of the Act 48 and that of 47. The learned counsel was not able to point out any matter of substance in which there is difference between the two enactments. It was suggested, whereas section C imparted for rules to be made and taxes, there was no specific power. It is not necessary to discuss the materiality of the point, because what we are concerned with is the power to levy a fee. And there is an express provision in section 30. Apart from the implication of 25, it says, any rent, royalty, fee, tax, or sum due to the government under the terms of the prospecting license, under the certificate, etc., may be recovered. We ought to add, so section 25 was referred to, that's very important. We ought to add that besides we see considerable force in Mr. Setalvat's submission, that 1 and 2 of 18 are wider in scope and amplitude and confer larger powers on central government than the corresponding provisions of the Act of 48. The second point urged by the appellant is based on that section 18 of the Central Act merely lays a duty. God, which page is it? This keeps jumping off. The second point urged by the appellant is based on the fact that section 18 of the Act merely lays a duty on the central government to take steps for ensuring the conservation and development of the mineral resources. The submission is that even assuming under the powers conferred there are in conjunction with 13 of the Act, it would be competent for the central government to frame rules in the line of the EUROSA Act for the development of mining areas, and for that purpose to provide for the imposition of fees and for the constitution of a fund. Still, no such rules have been framed, and until the rules were made, Central Act would not cover the field, and that the EUROSA Act would continue to operate. In support of this submission, reliance was placed on the on the decision of this court in Tikaramji and state of UP. That's the sugarcane case. Para 14. We consider the submission in relation to the Act before us without force, besides being based on a misapprehension of the true legal position. In the first place, the point is concluded in the earlier decision, in Hinger Ramco, where this court said that in order that the declaration is effective, it is not necessary that the rule should be made or enforced. All this is necessary is a declaration by Parliament that it was expedient in the public interest to take the regulation of development of mines under the control. In such a case, the test must not be whether the legislative declaration covers the field or not. But even if the matter was res integra, the argument cannot be accepted. Repugnancy arises when two enactments, both within the competence of the two legislatures, collide, and when the Constitution expressly or by necessary implication provides that the enactment of one legislature has superiority over the other. Then, to the extent of repugnancy, one supersedes the other. But two enactments may be repugnant to each other, even though the obedience to each of them is possible without disobeying the other. The test of two legislations containing contradicting provisions is not, however, the only criterion of repugnancy. For if a competent legislature with a superior efficacy expressly or impliedly evinces its intention, with an intention to cover the whole field, the enactments of the other legislature, whether passed before or after, would be overborne on the ground of repugnance. Where such is the position, the inconsistency is demonstrated not by a detailed comparison of the provisions of two statutes, but by the mere existence of two pieces of legislation. Hearing, having regard to the terms of 18.1, it appears to us that the intention of the Parliament was to cover the entire field, and thus to leave no scope for the argument that until rules were framed, there was no inconsistency and no supersession of the State Act. So they said 18 covers everything. Your Lordship may only mark, and I'll develop this tomorrow when I'm dealing with entry 50, that it is expressly or by necessary implication. It was next urged that the scheme of the legislative entries under the Constitution as previously under the Government of India Act, the power to levy fee with an independent head of legislative power under each of the legislative fields and not merely incidental power flow from the grant of power of the subject matter. It was sought to be established even if the Union could levy a fee under the Central Act. It would not effect or invalidate a state legislation imposing a fee for a similar service. The argument again proceeds on a fallacy. It is no doubt true that technically speaking, the power to levy a fee under the entries in the three lists is treated as the subject matter of an independent grant of legislative power. Whether it is incidental power related to a legislative head or an independent legislative power, it is beyond dispute that in order that a fee may validly be imposed, the subject matter of the main head of legislation, in connection with which the fee is imposed, is within the legislative power. The material words are fees in respect of any of the matters in this list. It is therefore a prerequisite for the valid imposition of fee that it is a matter in respect of the list. If by reason of the declaration of Parliament, the entire subject matter of conservation of development of minerals has been taken over or being dealt with Parliament, thus depriving the state of power to which it is possessed, it follows that the matter in the state list, to the extent of the declaration, is subtracted from the scope of entry 23. Therefore, there would, after the Central Act, be no matter in the list to which the fee could be related in order to render it valid. Now, this is a very important piece of listening. It empties out the list, as it were. And this is perhaps why Kannadasan said, if entry 50 is denuded, it shifts to entry 97. So it's not that 23 is still available, just that parliamentary legislation prevails.
So it's eclipsed.
It's gone. It's to borrow the words of the court, it is subtracted from the scope and ambit of entry 20.
Even then we again
One more paragraph, my lord. Although it is in the context of Section 6 of the General Clauses Act, there's a further discussion in para 19, page 292.
Yes.
Para 19, my lord, at page 292. Before proceeding further, it will be convenient to clear the ground by adverting to two matters. One, the effect of a central act under its exclusive legislative power, which covers the field of an earlier state act, which was competent and valid when enacted, is not open to doubt. The parliamentary enactment supersedes the state law and thus virtually effects a repeal. That's how the Lords looked at it. And then applied the Section 6 principle. And thirdly, in the trilogy is Bajnath Kedia, 69-3 SCC 838. It's at page 412 of bundle 4. Bundle 5, sir. 412 of bundle 5. Volume 5, sir. At page 414, the second paragraph of the judgment, one Jyoti Prakash Pandey obtained on March 23rd from Babu Bijan Kumar Pandey and Shrimati Anila Devi acting on our behalf, etc., registered leases to quarry stone, ballast boulders and chips from blocks so and so. The leases were to commence, and that is to say they were for a so and so period. Para 2 is important. On passing of the Bihar Land Reforms Act 1950, the ex-landlord ceased to have any interest from the date of the vesting. In their place, the state of Bihar became the lessor, and under Section 10 under the Land Reforms Act. The section of Section 10 were given below. After the vesting of the estate of the intermediaries, the state of Bihar as the next lessor recognized the lease for quarrying stone on the remaining period, and the Deputy Commissioner Santhal Paraganas asked for the rent, etc., etc. So that's how the land reform laws worked. The contention is to be found. The demand was raised just above paragraph 3 at page 416. The contention is that the amendment of Section 10 to the Bihar Land Reforms Act is ultra vires the Constitution, and 22 does not legally entitle the recovery of dead rent royalty in the schedules of the Bihar minor mineral concession rules. To understand fully the argument on behalf of the appellants, a resume of the legislation on the subject of mines and minerals is necessary, and the government, then the Government of India Act, entry 35, etc. You're not to have seen all this. And the federal word will change. Para 4 gives the 1948 Act. Your lordships have seen that already. Para 5 at page 418 says the leases of the appellant's predecessors were granted in 55. During the subsistence of the Act of 48 and the rules of 49, it is also to be noticed that a fresh declaration was made by Parliament as required by entry 54 list 1 union list of the 7th schedule. The existing laws, however, continued without a declaration by Parliament. the field of legislation might have been open to the state legislatures under entry 23 of list to state list of the constitution, but no law was made except what was enacted by the Bihar in the Land Reforms Act about vesting of mines in the state and the exertions of the state of the lessor in place of the lessors. Then, my lord, para 7, your lordship start dealing with the 57 Act. The whole discussion continues. Section 16 is noted, section 17 is noted, section 18 is noted, and para 10 at page 421, it may be pointed out here that the rules made under section 13 do not apply to minor minerals in view of the provisions of section 14. The state of Bihar has not made any rules under the Bihar minor mineral concession rules. The modification of the terms of the existing mining leases were provided for in section 16, but that provision applied to mining leases granted before October 49. The provision of mining leases modification of terms did not apply to minor minerals because the definition of existing mining lease excluded a lease of minor mineral. The power to modify leases in the case had to be found elsewhere. The argument of the appellant is that apart from the provision of the second proviso to section 10 added to the Land Reforms Act in 64 by Act 4 and the second rule added by Rule 20 of the Bihar minor mineral concession rules, there was no power to modify the terms. The provisions of law are said to be outside the competence of the state legislature and the Bihar government. With regard to the state legislature, it is contended that the scheme of the relevant entries in the union and the state list is that to the extent to which the regulation of mine and minerals development is declared by Parliament to be expedient, the subject of legislation is withdrawn from the jurisdiction of the state legislature. And therefore, Act 67 leaves no legislative field to the Bihar legislature to enact Act 4 of 55, amending the Land Reform Act. Now, the discussion begins.
Para 13.
Para 13.
About
Third line. Therefore, it is necessary to address ourselves to the first argument that the legislative competence to enact the amendment after the Act 67, we have to consider the position in relation to it. Entry 54 of the Union List speaks both of regulation of mines and minerals, development, and entry 23 subject to entry 54. It is open to Parliament to declare it is expedient in the public interest that the control should rest in the central government. To what extent the declaration goes for Parliament to determine, and this must be commensurate with public interest. Once the declaration is made and the extent laid down, the subject of the legislation to the extent laid down becomes an exclusive subject for legislation by Parliament. Any legislation by the state after the declaration entrenching upon the field disclosed in the declaration must necessarily be unconstitutional because the field is abstracted from the legislative competence of the state legislature. The proposition is also self-evident that no attempt was made rightly to contradict it. There are also two decisions of the court in Hingir, Rampur and Talak in which the matter is discussed. The only dispute, therefore, can be to what extent the declaration leaves scope for any legislation by the state legislature. If the impugned legislation falls in the ambit of such scope, it will be valid. If outside, it must be declared invalid. The declaration is contained in section 2 of Act 67 of 57 and speaks of taking under control of the central government the regulation of mines and the development of minerals to the extent provided in the Act. We have thus to look not to look outside Act 67 or 57 to determine what is left within the competence of the state, but have to work it from the terms of that Act. In this connection, we may notice what was decided in the two of the cases. In Hingir Rampur's case, then not Hingir Rampur is discussed, Talak is discussed, para 16, your lordship may see. These two cases bind us and apply here. Since the Bihar state legislature amended the Land Reforms Act after coming into the force of Act 67 or 57, the declaration to the latter act would carve out a field to the extent provided in the Act, and to the extent entry 23 would stand out down. To sustain the amendment, the state must show the matter is not covered by the Central Act. The other side must, of course, show that the matter is already covered and there is no room. We have already analyzed Section 67. The Act takes over the regulation of mines and development of minerals to the Union, of course, to the extent provided. It deals with minor minerals separately from other minerals. In respect of minor minerals, it provides in 14 that Section 413 of the Act do not apply to prospecting, license, and minerals. It goes on to state in Section 15 that the state government may, by notification in the official gazette, make rules for regulating the grant of prospecting license and mining leases in respect of mineral and for the purposes connected. And that until the rules made by the government regulating grant of prospecting license and mining leases of minor mineral, which immediately enforce, would continue. It is admitted that no such rules are made by the state. It follows that the subject of the legislation is covered in respect of minor minerals by the express words of 15. That's very important. So although the rules are to be made by the state, it is under the union legislation. Parliament has undertaken and laid down the regulation and grant of prospecting licenses and mining leases of minor minerals, and for that purpose must be by rules made by the state government. Whether the rules are made or not, the topic is covered by parliamentary legislation, and to that extent the powers of the state legislature are wanting. Therefore, there is no room for state legislation. So, this answers at least one point, that where it said the statement due to that extent 23 is preserved. That's not correct. Where the state is acting as a delegate of parliament, it is still 23 gets denuded. Then para 18 is also very important. Shri Lalnarayan Sinha argued that the topic of legislation concerns land and therefore falls under entry 18 of the state list. And he drew attention to provisions on the subject of mines in the Land Reforms Act as originally passed. The abolition of the rights of intermediaries in mines and vesting of these rights in the lessors of the state government was a topic connected with land and land tenures. But after the mining leases stood between the state government and the lessees, any attempt to regulate those mining leases will not fall in entry 18 but in entry 23. Even though the regulation incidentally touches land, the pith and substance of the amendment of section 10 of the Reforms Act falls in entry 23, although it incidentally touches land and not vice versa. Therefore, the amendment was subject to the overriding power of Parliament declared in section 67 of the Act of 57 in section 15. Entry 18 of the state list is of no help. Mr. Lalnarayan Sinha next contended that the provisions of section 414 do not envisage control of the union, which is a condition precedent to the ousting jurisdiction of entry 23. Obviously, Mr. Lalnarayan Sinha reads union as equivalent to union government. This is erroneous. Union consists of three limbs, namely Parliament, Union Government, and Union Judiciary. Here, the control is being exercised by Parliament, the legislative organ of the Union, and that is also controlled by the Union. By giving the power to the state government to make rules, the control of the Union is not negative. In fact, it establishes the Union as exercising control. In view of the two rulings of the court referred to earlier, we must hold that by enacting 15 of Act 67 of 57, the Union has taken all the power to itself and authorized the state government to make rules for regulation of leases. By the declaration and enactment of Section 15, the whole of the field relating to minor minerals came within the jurisdiction of Parliament, and no scope was left for the enactment of the second proviso. The enactment of the proviso was without jurisdiction. Just leave for consideration the second sub-rule added. It will be noted that the rule as stood previously applied prospectively and came into full after the regulation of the rules. The second sub-rule made applicable to those provisions to all leases subsisting on the date.
See, you have described your argument as the building block towards section 50,
Entry.
but tempting as they may be, these arguments don't have any connection with entry 50.
They do.
So
Very
should
good.
I say that
They do.
these are all cheese argument, whereas we are looking at staring at
No, but
chalk
they do.
argument?
They do. I have to get there. But I have to first start because there were 2 or 3 basic points which I need to get past. What is the extent of parliamentary legislation? What is the nature of parliamentary legislation? What is the run of the entries? What is the interaction between the entries? And my lord, because 54 and 23 are directly connected, 54 and 50 are directly connected. And how 54 operates is a very important element of my argument. That when one considers what are limitations, what is the approach brought to bear in interpreting entry 54 and the Act of 57.
But if you come to a case which deals directly with 50, you will be at least my concern, you will be able to assuage my concern
Yes.
on whether, where we are heading with the arguments that you are
Well,
advancing.
Lord, let me tell you, Lordships, except the High Courts and India Cement and Kesoram, nobody has dealt with 50 square. I mean, let's be clear, nobody has. I'm going to be showing, my Lord, the Patna High Court, the Mysore High Court, in my favor, the Punjab and the Rajasthan High Court against it. But, my Lord, ultimately, the High Court judgment, none of your Lordships are considering it. My interpretation of entry 50 of what is the true meaning of limitations imposed by law by Parliament, I have to clear the ground. And one of the important aspects my learned friend said is, look, so much is left to the state. Or mine and minerals are left to the state. That's not right.
Actually, Mr. Sarve, when we are operating squarely within the field of entry 23 of list 2, vis-a-vis entry 54 of list 1, once there is a declaration made by law enacted by a parliament, which is referable to entry 54 of list 1, the entirety of the field gets abstracted or subtracted, as the judgment said, from the field of the state legislature. And therefore, Parliament alone is then the exclusive legislating body on that subject, which forms the subject matter of the declaration.
Yes.
We are here in a situation where that principle would apply to tax on mineral rights. Now, even if there's a declaration under the central law, the MMDR Act, notwithstanding that declaration, Parliament cannot take upon itself the power to impose a tax on mineral rights because that doesn't fall within the scope of legislative competence of Parliament. The only then question is this, that's the distinction between these cases. The only question which then survives is whether the declaration by Parliament completely denudes the authority of the state legislature to legislate in the area of mineral rights, because any such legislation would impede the field of regulation and development.
I do not put it on that ground.
Unless you say that, look,
in fact,
taxation per se is barred because it will impede completely.
No, my Lord, I'm sorry. I put it on a very different.
Development.
I put it on a very different basis. There are 3 or 4 building blocks now to entry 50. And since, my Lord,
Well, one thing we are very clear now is that Parliament does not govern the legislative domain of taxation on mineral rights. This is not assigned to Parliament at all. Now, does a legislation by the state get affected merely because of the fact that there is a declaration by Parliament under entry 54 of list 2?
I'm not relying on the declaration. I don't rely on the declaration. That's why I said, my Lord,
But if you are not relying on the declaration, all these cases, the 3 cases which deal with entry 54 and 23, really of no relevance.
But for the field on field is not section only.
Yeah, that's not one. My Lord, these cases are relevant for the purpose.
It's a broad concept.
Yeah, exactly.
But they don't answer the question
No, my Lord,
for us.
but this is the, if I may say so, this is the canvas in which this question has to be now addressed. May I tell my Lord, may I formulate my point and then develop? I now come to entry 50 square.
How do you formulate it? Let's,
Yes.
so that, we got
The
about
entry, it's there in my written submission, but let me, my Lord, formulate it only. My case is that entry 50 is sua generis. It's a kind itself. The 7th schedule does not follow a fixed pattern of distribution of fees. There are different ways in which legislative fields are distributed. And each kind has its own nuance. Well, it might be helpful if I give, in fact, I'm going to give a skeleton tomorrow morning in writing, but broadly, this is what it is. And for interpreting entry 50, the skeleton submission. That's another point. My lord, your lordship will have to see the different ways in which these powers are distributed between the union and state. In order to give content and meaning to the expression, subject to any limitations imposed by Parliament by law relating to mineral development.
To give content and meaning to the expression.
Limitations imposed by Parliament by law relating to mineral development. Your lordships will also have to examine the subject matter of the tax. Taxes on mineral rights. And it is on an analysis of these two elements of entry 50 that your lordship will have to consider the validity of a state law imposing a tax on royalty. Where these cases would be of assistance to the court is in understanding in the constitutional concept or in its constitutional sense the nature of the Act of 1957, not just the declaration. So, my lord, let me be clear what my lord the Chief Justice was pleased to put to me, my lord. Declaration is not the basis of limiting 50. Unless I am able to make good that the 52nd Act, the 57 Act, in its different avatars, starting from 57 and as amended over and over again, considered the fiscal implications of state exactions as a essential element of development of mineral rights. And by section 9, exhaustively define what a state could exact for mineral rights.
Just kindly repeat this submission, sir. Section 9 exhaustively
Exhaustively defines
defines.
what a state can exact
Okay,
for mineral rights,
correct.
to the exclusion of any other kind of exactions. I would not be able to bring it within the limitations. I mean, I put my point negatively. That's what I have to show.
To the exclusion of
Any other kind of.
any other.
Contingent upon.
In course of your submission, you spoke about, those precious metals, gold and this thing, and you said it was the edict of the Raja. Can we have a bit of research done whether Rani also had something to do with that?
Raja, you must be holding Malad in trust
Malad,
for and on behalf.
Mr. Parasaran used to always tell us this. He says the most misunderstood notion is the male-female. He says we forget that the woman is the Ardhangini.
Yes.
And when you say the man, it's only half of the whole.
So Rani would have a role.
Malad, in today's world, Malad, it's lucky if the Raja gets some say. The Rani occupies the field. To the exclusion of the Raja.